Ladies and gentlemen, good morning and welcome. Today, the Journal of European Consumer and Market Law celebrates 10 years life and commitment. Commitment for strengthening consumer rights and for finding the right balance with traders' interests. This could not take place in more challenging times. Digital disruption, climate challenges, international conflicts, abrupt change of circumstances. This makes all the more important to strengthen our synergies and to constantly redefine the role of consumer and market law. For this purpose and reason, my fellow co-editors and I would like to thank each of the distinguished speakers and chairs who enthusiastically joined this initiative from Europe and beyond. A warm thank goes also to the other participants in the room for being here and for their contribution to the discussions and to improving or even changing our ideas. If we are here, it is because of an idea of my brilliant co-editors back in 2011, the idea to offer to you this journal. So the thank goes to Christoph Busch, Mateja Djurovic, Catalina Goanta, Mateusz Groszowski, Joasha Luzak, Vanessa Mack, Jorge Moraes Carvalho, Christine Nemeth, Rupert Potson, Sofia Rancordat, and Christine Riefer. Working with you is every day a great pleasure and enrichment. Not to forget Stefan Keiler, Ronny Domrös, Ulrich Ernst, who delivered a fundamental contribution at the beginning of this journal's history. A special thank goes also to the distinguished members of the UCML Advisory Board, and especially to our first speaker, Verica Trsteniak. She, with her fundamental contribution in her role as Advocate General of the Court of Justice of the European Union, can be considered one of the mothers of European Union private law. And also one of the mother of our journal, as she wrote the very first editorial back in 2012. EU consumer market law is an essential engine of European integration. It is therefore one of the key tools for facing two of the crucial challenges of the current and next decades: digital revolution and environmental sustainability. The last years have indeed seen consumer law elevated to being a central pillar of European Union policymaking, with the European Union setting a high level of protection for consumers in all industries and markets. This has led to the adoption of many legislative instruments, all requiring complex technical knowledge. In addition, the fourth industrial revolution and recent digital developments have again opened the floodgate for new regulatory initiatives, tackling critical issues such as sustainability, global electronic commerce, and the liability of digital services and market actors. Meanwhile, the common European rules regulating different areas of consumer law, such as unfair commercial practices, unfair contract terms, consumer sales, or dispute resolution, continue to evolve and remain of utmost importance for both online and offline transactions and market interactions. The harmonization of consumer laws has in principle raised the level of protection of consumers in the international market as businesses offer goods, services, and digital content across borders within and outside of the European Union. However, the application of consumer law is as difficult as it has always been, prompting the need for yet further reforms. So the Journal of European Consumer and Market Law offers a timely and critical analysis of all new developments and revisits old ones to preempt market needs and suggest viable solutions. In particular, UCML offers an innovative perspective on consumer law that goes beyond the traditional understanding of consumer law as consumer protection law. Indeed, it understands consumer protection from a market perspective, taking into account the requirements and realities of doing business in B2B and B2C markets. Therefore, this journal welcomes analysis that encompasses work aimed at protecting consumers stricto sensu, but also as users of services, passengers, insurance policy holders, etc. So EUCML offers also a forum to discuss the black letter law implications of the latest member states' courts and Court of Justice of the European Union interpretation, but also sustainability concerns, the effects of the pandemic of COVID-19, data commercialization, issues of power in markets, or even social aspects. Therefore, the UCML is focused on bringing scholarship and the sharpest thinking on the issues that matter to the consumer and the market for the 21st century. UCML is available in paper as well as online on Hein Online, Kluwer Law Online, and Beck Online. So the contributions from this conference will be published in the forthcoming issues of the UCML. And Beck, the publishing house Beck, generously offers 2 2023 free issues of the UCML to those who are interested. So the order form is available on the UCML website, www.ucml.eu, and you can find more information there. So looking at the multifaceted changes and challenges, which require a new balance between different values, rights, and duties, my fellow co-editors and I wish you 2 fruitful days of presentations and discussions. Thank you very much. And now, leave the floor to my fellow co-editor, Christoph Busch. Christoph, you have the floor. Thank you.
Chair the very first session of our anniversary conference. Before I open the session, let me mention that this is not just a special day for our journal. It is also a special day for Alberto, because not only the journal is celebrating its birthday, also Alberto is celebrating his birthday today, which I think is a wonderful coincidence. So let us express our congratulations with a warm round of applause, if you like, to Alberto and to the journal. This being said, let me introduce the first session. And this session will look at the big picture of European consumer and market law and overarching challenges of EU consumer and market law, as the title expresses it. And for this purpose, we have an excellent lineup of 5 speakers, which I will introduce step by step. And these speakers somehow represent the diversity of our journal. There are long-standing friends and supporters of the journal among them, and there are new voices. And this somehow reflects that the journal is a sort of intellectual community, bringing people together who are interested in EU consumer law and EU market law. And as you know, a journal is nothing without good authors, without you. I see many people in the room who have already written in the journal, have contributed to EUCML, and I'm very much looking forward to contributions by those who haven't yet written for us. So please feel yourself invited. And this brings me to the very first speaker, Verica Tresteniak. She wouldn't need an introduction, but I still say 2 words. As you know, she's a former Advocate General of the European Court of Justice in Luxembourg, a member of the Executive Board of the EU Agency for Fundamental Rights, a professor of EU law, and, as Alberto already said, a strong supporter of our journal from the very beginning. She is actually author number 1 of our journal, because as Alberto mentioned, she wrote the very first editorial for the very first issue of this journal. So I think it's very fitting that she's also the first speaker of this anniversary conference on the topic Wish or Reality, Reconciling Consumers' Needs and Traders' Goal. Veritza, the floor is yours. Thank you for being here.
Thank you so much. At first, I will try to share my PowerPoint. I hope that you can see it. Alberto, can you see it?
Yes, perfectly. Thank you.
Right. You can hear me. Okay, so yeah, it's really great pleasure to be with you today. How to say, on this birthday party, actually, but we celebrate this with our efforts, with our knowledge, with our lectures for better consumer protection and also for better market situation for traders. As it was mentioned already, I wrote the first editorial 10 years ago with the title, Do we need a new journal in this area? I think that we have an answer, that we need it. And I wrote also the editorial for this 10th anniversary journal. And there was my question, actually, is this wish or reality? Happy consumers and happy traders. And today I will try to, how to say, to mention few important issues, how to achieve this goal. I will go back to this famous quote of Kennedy. As you know, this is like consumer bill of rights in our area, which we are all very active. And at that time, he mentioned 4 original rights. And this is right to safety, to be informed, to choose, and to be heard. And as we know, today, these rights are, how to say, are developed today. Consumers has rights also in other areas. And this is important that also consumers are aware about these rights, but also that traders respect all these rights. So that I would like then to start with this question. What is the more important right, or not really right? What is the more important issue for consumer? And what is the most important right or issue for trader? When we speak about rights, maybe you would say data protection, but for consumer. But I'm not so sure, because very often the consumer has an interest for lower prices and also for good quality. But on another side, then we have a trader. His idea is to achieve high price. So that how to find here the fair balance. And what is also important, actually, for both parties, it's effective legal protection. We know that according to the CETA agreement, this free trade agreement with Canada, there was also an opinion at the European Court of Justice concerning this problem, concerning actually legal protection concerning this international agreement. So that these are all important issues for consumers and also for traders. And then the next important question, who is actually guardian of consumer rights? And who is actually guardian of traders' rights? Is this European Commission? Is this state, national states are guardians? Or are these courts? Courts at the national level and courts at the European level, European Court of Justice. Or, as you can see also, is this maybe legal theory and legal journals? So that I think that we have to find a good solution in the mixture of all these institutions and all these factors. And the next question concerns the problems. As we can see here, consumer and traders, they both have similar problems. But do we have to search for the different solution or for the same solutions? For example, consumer would like, very often the consumers say that we have too many legal acts. The same, the trader would say, too many legal acts at the national level and also at the EU level. And then concerning, for example, digital age. As we know, consumers are always, how to say, criticize this, that there are so many new problems, the problems of data protection and so on. But also the trader see, or they are faced with many new problems in digital age, also in data protection, but from another side, how to find a solution for consumers. The next important issue for both sides also is legal protection. Consumer would like to have an effective legal protection, but also trader would like to have effective legal protection concerning different problems like how to say fair trade, fair price. We in many countries we have problems with Swiss francs credits and so on. Then important for both sides are also rights, fundamental rights. Here we can see that rights of the traders are different as rights of the consumers. About this I will speak in the next minute. And what is also important as for consumer is, as you know, it was confirmed in many judgments of the European Court of Justice, is a weak party, but this could be a problem for trader, because trader would like that he is, how to say, at least at the same level. So that this is, we will see also, it's very, very difficult to find this fair balance. But there are also other problems. So that we have to find not always the same solution, but we have to find the appropriate solution for both sides. The next also important issue is what comes first? Is this practice? For example, we can see here self-driving cars, or for example, Uber. It's a practice, but it's always first, or sometimes is this, for example, legal act, a new EU directive, a new EU regulation. But we know that we have, for example, already, I don't know, Uber in many countries or other important new developments, but we don't have an EU legal act, for example, a new EU legal act. But this means that it is very important that we have all the time legal theory. Legal theory also from the beginning, when there are problems in the practice, or if we have already new legal acts, we need a legal theory to criticize this, not to criticize, and also to say this is we have to welcome this because we would like to welcome this because there are very good solutions, or in this directive we can see bad solutions, so that it is necessary to improve the legal acts, and this is the important role of legal theory. For example, also our European Journal for Consumer and Market Law. And the important role has always also court. This means national courts at the national level and at the EU level, European courts, especially European Court of Justice. Important, it is also for the consumer and for trader, a new legal act. This is EU Charter of Fundamental Rights. I think that you are all familiar with this new legal act. As we know, we have a special provision for consumers in Article 38, consumer protection, and there are many other important provisions for consumer, from the right to information, or, for example, property rights and other rights. But also for the traders, it's important that in Article 16, it's actually the first time this actually constitutional level, it's written this right for traders or for enterprises, freedom to conduct business. And if you analyze the judgment of the European Court of Justice, you will see that in many judgments you can find when one of the parties is one enterprise, you will find this freedom to conduct business. Sometimes there are also property rights or freedom to information and so on. So the most important role of the European Court of Justice, as I can see this from my point of view in this area, especially in the area of consumers protection and also in the area of market law and traders' rights. The first one is very important for consumer as a big party. You can find this principle in many judgments of the European Court of Justice, and then not to speak more about this because you are all familiar with this principle. And the next, also very, very important principles, and we can always, keep both these principles together, consumer as a big party, but also fair balance. Fair balance of interest of two parties, the consumer on the one side and the undertaking for trader on the other side. So that, for example, there is only one case, Amazon, for example. So that always, as I said, we have to keep both when we discuss about the rights of trader or the rights of consumer. Important are also fundamental rights. It was mentioned already in many judgments. We will find different fundamental rights for consumer and for trader. There's some only here you can see only few cases like Lidl, Neptune, and so on. And also important is also the role and influence or impact of the European Court of Justice in the area of digital age. There are different new judgments, not only Google, Spain, and Schrems, but also new judgment concerning Uber and other new practices in digital age. As example, just to mention this case, I think that the majority is familiar with this case, but just to show how important is this, that there is somebody who decides at the end when there is a problem, because as you know, we don't have an EU directive in this area, but this practice was here, so that when the European Court of Justice got this preliminary question to decide about these services provided by Uber, the Court of Justice had to decide are these services transport services or these information society services. This is very important for the results and for the rights and the duties of both parties. So that, as you know, the Court of Justice decided that services provided by Uber connected with individuals, with non-professional drivers, that these are services in the field of transport. This is very important because the Court of Justice decided here, how to say, in more conservative way, so that it is not the same situation as, for example, in the United States, where this is more liberal. And what does this mean? This means that also this is important for the consumer protection, because if this is the part of transport services, this means that there is high level of the consumer protection, and this is very, very important. But there are still many open questions also concerning labor law and so on. But anyway, this is already one step, I think, actually in the right direction, because in the European Union, this development is not the same concerning the new practices as in the United States, for example. And now about the future, and to answer about my question, is this only a wish or is this reality, happy consumer and happy traders, consumers and happy traders? And what is in the role of our journal? So that what do we need actually? What do we need? We need consumers who are aware of their rights. But we need also responsible traders. And we need respect of rights on both sides, not only on the side of the traders, but also on the side of consumers. Then we need, it is very, very important, the next two issues are very important. We need really transparent legal system. This means at the national level and at the European level, because as you know, if we have too many legal acts, this is also not something that is good for the legal protection. And we need effective legal protection, and this means we need courts which are effective and which are independent, also again at the national and at the EU level. And we need, from the beginning, this means from the step when we have only draft of a new legal act, or when we have only practice, and until the end, when there is really a problem already in practice, we need an objective and developed legal theory as to help to solve the problem, to help to develop the legislation, and to help to develop the practice, so that there will be not so many violations also from the side of the traders. So that I think this is our really important role, not only as a journal, but also our role as as legal experts. And in all these cases, in all concerning all problems, it is important that we find a fair balance. So it was mentioned already at the beginning, to fair balance between the rights of the consumers and the rights of the traders. So that, and this is not only this is the role of the courts, but this is also our role of legal theory, always to mention this, and always to say this is important. And also when we publish a new article, always to keep this very important principle. So I would like to conclude. As I said, it is very important, this cooperation and also respect of the rights of the consumer and of the traders. So that, and this is especially important in the crisis, as you can see, it is within crisis, because we had a financial crisis, we had a COVID crisis, and now we have energy crisis. And I read somewhere this sentence. I think it's also very appropriate for this subject. When the sun is shining, sunflowers turn toward the sun. And this is in the time when we don't have crisis. But when it is raining, the sunflowers turn against each other. So that I think that in this crisis, also the trader and the consumer, they have to turn against each other for better future of all of us. So that I would like to conclude with really best wishes to our journal for the 10th anniversary. But we don't have cake here, and we don't have champagne. Maybe you have this in your private rooms, but not online. It is not possible to drink and to eat. But I think what is important, our cake, our contribution, our cake is our knowledge, and our champagne are our publications. So that in this, direction, I would like to say to all of you, but also especially to our journal, Vivat Crescat Florel. Thank you so much for your attention.
Thank you so much, Veresa, for this wonderful opening speech, and for referring to the, as you said, sparkling contributions to our journal. That's a wonderful metaphor. Thank you so much. And this brings us to our second speaker, and I'm happy to introduce Andrea Stasi, who is a professor of comparative law, intellectual property, and new technologies law, and also the director of the Innovation Law Laboratory at the European University of Rome. And he's also a visiting professor in biotechnology law and academic fellow of the Center for Technology, Robotics, Artificial Intelligence, and the Law at the National University of Singapore. And I think that's also a very fitting coincidence that we have a speaker who bridges Europe and other regions, because over the past years we have learned that our journal is not only read in Europe, it's also read beyond Europe. We have readers in India, in Korea, in Japan, and sometimes even authors from there. And I think this is a good sign that the discussion on on the future of consumer law is much broader than just the European academic community. Andreas Stasi will speak about the protection of weaker parties in smart contracts, and he's an expert on this subject. He has published a book on smart contracts and comparative law, which was published with Springer in 2021, and I'm very much looking forward to your presentation. Professor Stasi, the floor is yours.
Thanks a lot, Christoph. Thanks a lot, Alberto, and all the editors of this great journal. And good morning, everyone. First of all, let me add a +1 to the cheers toast to this very important anniversary. I do hope that the European Union approach to consumer protection continue to inspire more and more, I would say, other continents, other jurisdictions all around the world, including Asia, as Christoph was mentioning. So in these few minutes, actually, I will try to mention some thoughts about the application of consumer protection to smart contracts, whatever it is. And I would mention in a while the doubts and the criticism in literature about the definition. But I think it's very important that we as legal academics and professionals, we look at the application of the European approach to consumer protection to this area that's probably not really a category, but it's something that can be sometimes legally relevant. And I'm getting into the presentation now. It will be short, obviously, so I will send the contribution with a longer version. As we know, the development of distributed ledger technologies, such as the blockchain, allows the creation of so-called smart contracts, which are characterized by the self-execution of the contractual clauses without the need for human intervention, and generally, at least, excluding the possibility of interrupting this execution or modifying the content. In some cases, the smart contracts, between brackets, because I'm getting into the definition in a legal sense or not in a while, represent the implementation of a previous contractual agreement in the legal sense, the clauses of which are formalized in the computer code. In this case, obviously, the contract is not in the computer code, but it's in the previous version of the contract. Thus, the contracting parties have the advantage of structuring their relationships and services in a more efficient and self-executing way, regardless of the ambiguity of natural language. In other cases, smart contracts introduce new codified relationships that are both defined and enforced automatically by the computer code, but are not linked to any underlying contractual right or obligation. So, in this case, smart contracts can be a misleading definition because it's not properly a contract in the legal sense, but is related to information technology. In any case, regardless of the technical necessity, there might be a legal need to draw up a smart contract in writing in order to make its clauses legally binding and enforceable at the judicial level. A smart contract, furthermore, is not always immutable, because first, the blockchain could be forked by the majority of users, and secondly, the computer code may contain some functions that allow a certain range of flexibility, such as, for example, the so-called multi-signature, where multiple parties have to sign the contract before having it binding, or self-destruct, that's self-explanatory. In a technical sense, smart contracts are self-executing computer protocols, which apply the lines of computer code for which they were programmed and stored in a distributed ledger, such as blockchain. Possibly, were through them an economic function recognized by the legal system in which they are intended to perform their effects is pursued, they allow the drafting, at least in my opinion, they allow the drafting and possible automation of agreements between the parties as a truly contractual case in the legal sense. That is, according to some authors, smart legal contracts. So smart contracts in a proper legal sense with legal effects. Even in this case, always according, that means limited to a logic of if-then, so a computer code logic that should make it easy to draft the computer code and can't allow for the complex contractual clauses to which we are all used. A program of a smart contract runs from a network of so-called miners who, once consensus has been reached on the outcome of the execution, consequently update the status of the contract on the blockchain. In these ways, users can send or receive money, data, etc. through a contract. Therefore, relying on the capabilities of the blockchain, smart contracts operate autonomously in a transparent, tamper-proof, and basically immutable way, apart from the exceptions that I mentioned. These features allow the contracting parties several significant advantages compared to traditional contracts. They can rely on contractual promises that are stored in the smart contract, that is, the transaction protocol, is automatically executed without recourse to judicial intervention, and they do not have to trust the counterparty. This allows the parties to take calculated risks, even in areas where the parties are not directly opposed to each other, but which are often characterized by anonymity and enforcement risks, as is typically the case in, for example, in e-commerce and international contracts. Consumers or users, in particular, could benefit significantly from these advantages, as they usually face difficulties or costs which cause them, in fact, to neglect to enforce their rights in court. Automatic enforcement or compensation have the potential to reduce the amount of litigation by increasing certainty and reducing the cost of monitoring performance. In general, therefore, smart contracts give rise to a further reduction of human intervention and formalization of the contract. Compared to traditional contracts, again on the side of advantages, and get into the challenges in a while, smart contracts increase the speed with which contractual relationships can be executed. Since they do not depend on paper and related procedural steps and can be executed in real time, they also allow for cost saving and faster execution than paper contracts. Now, let's come to the legal issues. On the other hand, smart contracts also present a number of new issues and challenges for the law and practice of trade. First question that may arise is that of the identification of the other contracting party. If the blockchain allows anonymous or better pseudonymous transactions, such as, for example, in the case in which the transactions are recorded by referring to an IP address or a cryptocurrency wallet, the codification of the clauses in computer language could lead to a limitation of the possible contents of the smart contracts, linked to the possibility of automating the contractual prose according to the if-then logic, as I mentioned earlier. And connected to this is the risk that the code drawn up by computer scientists incorrectly reports the provisions of the contractual agreement between the parties, or that it may operate differently than planned with the related question of the attribution of responsibilities, liabilities, etc. Also, there is the question of the risk of not understanding the smart contracts by the parties and even their legal consultants. In practice, these problems are increasingly addressed through the connection between the text in computer code and a contractual text drawn up in natural language, which may have the same content, and in this case it's a so-called split contracting, or be one, the smart contract, the specification or execution of the other written contract, and this is the case of the so-called hybrid agreement. Finally, regarding the execution of smart contracts, contrary to traditional contracts, in which the parties can decide whether or not to fulfill their obligations, a smart contract cannot be hacked. And this is even more important in common law jurisdiction and sensitivity, but I don't have time to deep dive into that here. What about the protection of weaker parties, in particular consumers, in the European Union approach? So, from the point of view of legal protections, although the implementation of basic contractual guarantees and consumer protection rules in smart contracts is theoretically possible, in fact, it can prove complex, given the formalized and deterministic nature of the computer code. Regardless of the method of concluding the contract, with reference to the relationships between professionals or traders and weaker parties, in particular consumers, smart contracts, on the one hand, have the potential to facilitate the protection of the latter, as I mentioned, as they can automate it by eliminating the possibility for professionals to count on the counterparty's inertia in activating their rights. On the other hand, smart contracts pose relevant questions because of their rigidity and complexity. Therefore, although doubts have been expressed as to the compatibility between the general structure of smart contracts and consumer protection legislation, the latter must be considered applicable where the requirements for its applicability are met, obviously. The restrictions provided for standard contract terms, first of all, by European contract law, can also apply to smart contracts. Some authors have argued that consumer law in principle applies to smart contracts, but have questioned the applicability of the Unfair Terms Directive 93/13, as it would imply a non-existent textual unfair contract term in the case of an algorithm. This objection is, I think, is unconvincing, both because the Directive on Unfair Terms and the subsequent EU legislation on consumer protection do not require a textual document for their application, and especially, I would say, because it would be counterproductive if the protection granted therein could be easily circumvented by converting the unfair terms, etc., in the computer code of a smart contract. In contrast with consumers, as is known, the fact that a certain term or its specific aspects have been negotiated individually does not exclude the application of the rules on unfair terms to the rest of the contract, if an overall assessment of the same indicates that it is a standard contract, as it's often the case in the smart contracts drafted by smart contracts platforms. Such rules seem fully applicable even in the cases in which the clauses of the smart contracts act as standard contractual terms, or the contract themselves have been prepared unilaterally by one of the contracting parties. For both hypotheses, in fact, the trader bears the burden of proving that a standardized clause or the entire contract, the entire contract prepared by him or her has been the subject of individual negotiation with the consumer, as we know. Where instead, as mentioned, frequently occurs in commercial practice, the parties make use of forms possibly prepared by platforms for smart contracts, as it's common in the practice, which have been assembled and customized on the basis of their specific needs by the parties themselves or by their respective legal consultants. Such personalized forms can be considered outside the scope of the rules on unfair terms. obviously with the exclusion of any clauses, any part of the formalized of the form that has not been individually negotiated. Directive 2011/83 on consumer rights provides for various rights and related information obligations, for the exercise and respect of which, on the one hand, it appears necessary to use a text written in natural language. On the other hand, it must be taken into account that, at least in current practice, one of the parties for a multitude of smart contracts usually does not draw up contractual forms in advance. Instead, is the platform providers for smart contracts which prepare such forms. Therefore, in any case, the professional, the trader, will have to verify that the platform includes the information required by consumer law or integrate that with the missing information. In the event that the smart contracts are not negotiated individually, therefore, their clauses will be subject to the obligation of good faith and to the prohibition of giving rise to significant imbalances in the rights and obligations of the parties, both envisaged, as we know, in the directive on unfair terms. In this context, a provision of particular importance for smart contracts is the list of potentially unfair terms mentioned in letter Q of the annex to the directive, since self-executability could result in limitations on consumers' ability to take actions or appeals or exercise legal remedies. Other provisions to consider regarding smart contracts are those referred to in Article 5 of the Directive on Unfair Terms and in Articles 7, 8 of the Directive on Consumer Rights, according to which the pre-formulated terms must always be written in a simple and understandable language, and the professional must provide the consumer with the mandatory information appropriately to the means of distance communications used, again, in simple and understandable language. In this regard, if on the one hand the parties are in principle free to choose any language for stipulating the contract, including the computer language, on the other hand, in relationships between professionals and consumers, such an autonomy seems considerably limited by the previously mentioned standards and rules, being difficult to state that computer code is a simple and understandable language for consumers. Consequently, it can be assumed that the professional is required to provide the consumer with a translation of the computer code that is clear and understandable, that is in natural language, in fact. With reference to the right of withdrawal to be exercised within 14 days, 14 working days, in the smart contract, it could be implemented, and it is in some cases already in practice, by programming it so that its execution remains suspended within the first 14 days of the conclusion of the contract. At the end of this period, the smart contract will verify automatically whether or not the condition for exercising the withdrawal exists, and if not, it will give rise to automatic execution. Further relevant rules for smart contract at European level, and then going to the conclusion, are envisaged in the directives 2019 770 and 771 that are respectively on contracts for the supply of digital content and services and for the sale of goods in which such content and services are incorporated in or interconnected. These directives, as we know, provide that the digital content or service or supporting goods must correspond to the description, quantity, and quality provided by the contract, presenting the functionality, compatibility, interoperability, and other characteristics foreseen by the same, and be suitable for the purposes for which such digital content or services would normally be used. This taking into account any European Union or national law and existing technical standards, or in the absence of them, the specific codes of conduct of the relevant sector. Therefore, this provision subject the terms of smart contracts to a check of correspondence with what was agreed and of adequacy for the use of the content or service provided. Such characteristic will have to be evaluated, unlike the rules on unfair terms, with respect not only to regulatory parameters, but also to the best market practice. Lastly, the Omnibus Directive 2019-2161 amended some of the directives mentioned so far by introducing enhanced consumer protection enforcement measures and greater transparency requirements, imposing additional obligations for B2C contracts and incorporating in the previous protection provisions the definition of goods and services and digital services, including free services offered in exchange for personal data. In this regard, actually, increased transparency obligation for professionals, including information requirements for online marketplaces regarding the identification of sellers and the algorithms used for classification of search results, could be difficult to meet for smart contracts, more than in general. In fact, they can be concluded and executed directly between parties that may be unknown without an intermediary platform and automatically entering into a contract and potentially executing it without even worrying about who the counterparty is. In conclusion, as for each of the issues that I briefly mentioned so far, the solution will have to be identified on a case-by-case basis, and putting together the provision, the general provision, that are more and more up to date with the digital environment for consumer protection, with the technical characteristics of such innovative bargaining tools. This analysis should be based on the spirit of the law that is common to the various directives mentioned, which seems to ensure the best possible protection for weaker parties, depending on the cases with respect to or by virtue of, some cases, of the technologies used in the contractual context of reference. Because, as I mentioned, the smart contracts present various challenges from the legal point of view, but also some interesting opportunities to enhance consumer protection. Thanks a lot for your attention.
Thank you very much, Andrea Stasi, for this excellent analysis of the challenges and the opportunities that smart contracts bring for consumer law. And we continue our Tour d'Europe from Rome to Leuven, another important center of research on European consumer and market law. And I have the pleasure to introduce our next speaker, and that is Bert Kaarsbilk, a professor of law at the Faculty of Law and Criminology at the Catholic University of Leuven. He lectures commercial law, EU law, and European economic law, also in Brussels and in Kortrijk. And his recent research focuses on sustainability, production and consumption, circular economy, and also servitization. And as regular readers of our journal know, Bert Kaarsbilk has already extensively published on these topics, also in our journal. And we're proud to say this, that we have you as an author. So, Bert, the floor is yours. I assume that you're trying to share.
Yeah, I want to share my screen, but apparently something went wrong.
Yeah. Alberto, who is our chief technician, chief technology officer, can you help us?
Does it work?
No, not yet.
Yes. If you would like to send me the slides, then if it doesn't work at your side, I can move the slides for you.
can I maybe send my slides to you?
Yes.
I'll quickly do it. Apologies for that. Should have them now, Alberto.
Moment.
Well, maybe I can already start in terms of timing. I think I have 15 minutes.
Yeah, that's
Is
right.
that it?
Excellent.
Well,
Yeah.
first of all, I would like to thank you for having me today, especially Chair Christoph Busch and Alberto De Franceschi. Would like to congratulate you with this event and with the magnificent journal. In no time, it has grown into really a leading journal in the field, to which many of our CCM researchers also already have contributed, as you already mentioned. Today, I would like to say a few words on the ongoing legislative file for a directive amending the UCPD and the CRD, Consumer Rights Directive, as regards empowering consumers for the green transition through better protection against unfair practices and better information. On the one hand, the proposal seeks to step up the protection of consumers against unfair practices that prevent sustainable purchases, such as greenwashing practices and early obsolescence practices. On the other hand, it seeks to promote commercial guarantees exceeding the 2-year legal guarantee, to require information to be provided on software updates, and to provide better information on durability and repairability of the purchase. So I will make some general observations, raise some questions. Answer will follow perhaps also in the debate and certainly in the paper that I will finally submit. I would like to start with a number of more general observations, and I don't know whether the slides already. Okay, great. So we can immediately go to slide 3, I would say. Some general observations on consumer law and the linear economy, then look at the Commission proposal, and then come back to more general issues related to the shift towards a more sustainable consumer law. You all know, of course, that there's a lot of legislative files. Empowering consumers for the green transition is just one of them. It is complementary with the SPI, the Sustainable Products Initiative, which was also that proposal published on the same date, and will follow hopefully soon initiative such as the Green Claims Initiative and an initiative in relation to the right to repair. As already mentioned, we have also contributed to some or given input to the institutions, both to the European Parliament and to the European Commission with our team. So today I will focus on specifically on empowering consumers for the green transition. Few more words on the what is the background of all this? Well, of course, as you know, it's part of the European Green Deal under the von der Leyen Commission and the new Circular Economy Action Plan. As you see on the next slide, it has to do with the shift from a linear to a circular economy. So what I like to stress, and that is already the next slide, please, is that consumer law, as it's the slide behind that one, please, is that consumer law is really very much focused or calibrated still on the traditional linear economy. And that is very clear, both from the UCPD, for example, and the CRD as it currently stands, where you have this traditional view of consumer law seeking to create an interest between, or as a corrective mechanism, trying to find a balance between the economic interests of consumers and businesses with a focus on the short term, without taking due regard to externalities of sustainable production and consumption. As if, on the next slide, as if consumption takes place in splendid isolation. No account is being taken in traditional consumer law, I would say, of the take-make stage and the dispose stage. And these externalities are perceived merely as problems to be addressed by other fields of law, such as public law or product legislation or environmental law, waste law, not by private law. So the idea is to focus on one of these files and on the proposal empowering consumers for the green transition based on Article 114. It is a traditional consumer protection directive, you could say, in that it will it really takes the position of trying to enhance consumer rights in making informed choices. That's already on the next slide. Apologies, can't help. It is traditional in that it chooses this information model in proposing mandatory information requirements, ensuring non-misleading character of the information that is voluntarily provided by businesses on the market. Okay, that will be strengthened. On the other hand, it is innovative because it brings this environmental protection as a public interest into those directives that were up until now focused merely on the protection of the collective interests of consumers vis-à-vis businesses. And that's the general idea that I would like to make. And also, it's complementary with the SPI, which takes a further step, Sustainable Products Initiative, which will apply to all movable goods, and which implies a more thorough intervention in the design and production stage through regulation of product requirements to make products more sustainable, repairable, etc., in order for them to be allowed on the EU market at all. So in relation to this instrument, there's it's currently in the European Parliament. Draft report, the Borzan report, was considered end of October. Amendments will be, the deadline was end of November for amendments, and the IMCO committee will have a final vote on this end of March 2023. In the meantime, in the Council, under the French and the Czech presidency, the negotiations are ongoing in the Working Party last week. The presidency presented a second amended draft proposal that was discussed at length, and I will also come back to that. So my aim is briefly to discuss the state of play and make a critical assessment. I will do that more thoroughly, of course, in the paper. And it is clear to me that there's a lot of flaws in the wording of the proposed amendments. So please, maybe we can have a look at the UCBD amendments, and I think I will skip the CRD amendments and then come to some final untidy endnotes. So as to the UCPD, the next slides, please. Yes, currently, and there's in relation to misleading practices, no explicit prohibition to mislead in relation to sustainability issues, environmental performance, and the like. So that will change with a couple of amendments. On the next slide, you will see that environmental or social impacts, durability, and repairability would be added to the list in relation to which businesses could not mislead in their commercial practices. These concepts, these new concepts, are not defined in the directive. The selection seems a little bit random to me, and certainly in relation to environmental and social impact, this is very broad. It also includes, according to one of the recitals, social sustainability, working conditions, charity contributions, animal welfare, and the like. And it follows from the discussions in the Council that member states also in this regard would welcome more clarity and consistency also with other union legislation, such as definition of durability in the in the CGD, repairability, for example, in the eco-design regulations. Second, the next slide, please. 2 more practices would be explicitly mentioned on the lists of practices that can be found misleading on a case-by-case basis. Okay, that's still on this slide. So making an environmental claim about future environmental performance without clear, objective and verifiable commitments and targets and without an independent monitoring system. Here again, the notion of environmental performance is not defined, although of course we know a definition of this in the eco-label regulation, for example. So again, it would be good to have a consistency in terms of definitions of new concepts which are introduced in these already these directives which are already suffering from verbosity, I would say, words. So at least we should then define those properly. The second one deals with advertising benefits for consumers that are considered as a common practice in the relevant market, and the example being given, if you highlight that a product does not contain a chemical substance, where the absence of that substance is a common practice, well, for that particular product, then you could not make that type of advertising. Another amendment on the next slide has to do with sustainability information tools, a concept which is defined in the directive. It follows from in the proposal, it follows that this is again very broad, includes not only environmental but also social aspects, all kinds. The idea is that businesses increasingly use this type of marketing practice where they compare the sustainability of products vis-à-vis competing offers. There's a number of elements in this provision, but I find it a bit strange that no conceptual link is made, for example, with what we know under comparative advertising law in Article 4 MCAD. Then I go to greenwashing, I'm checking timing. Greenwashing, there's a lot. On the next slide, please. We are, of course, all confronted with this, and the Commission wants to be able to step up enforcement through adding a number of new bans in relation to greenwashing. Next slide, please, on the blacklist. That's basically these 4 that you have there. The first one deals with the sustainability label, which is not based on a certification scheme with certain minimum transparency and credibility conditions, or not established by public authorities. The second one deals with these famous generic environmental claims, which are already clearly follows from the current UCPD guidance of end of 2021, that these are not as such allowed. They would be explicitly prohibited if their excellent environmental performance cannot be demonstrated, for instance, by compliance with the EU eco-label or other schemes. The third one is a more specific one. Maybe I will skip that and I go to the last one, Article 10 or point 10a, presenting requirements imposed by law as a distinctive feature of a trader's offer, for instance, while highlighting that a product contains a chemical substance when the substance is prohibited by law for all products. Here again, of course, there's an important link to make with eco-design. So if you present certain product requirements, or with the packaging waste directives and so on, if you present a product requirement as something special, whereas it is imposed, well, it will be a perceived misleading practice. Then we can maybe move to the slides on premature obsolescence. There's a lot of ongoing at the national level, and tomorrow one of my PhD candidates will defend a thesis on this topic. There's a lot to do about it. The UCPD currently does not contain specific rules to defining such practices, but that will probably change. We have a long list of 6 new per se prohibitions which are proposed, and that's on the next slide. The second one specifically deals with planned obsolescence, where you omit to inform the consumer about a feature of a product introduced to limit its durability, and so it's designed to fail, and you do not inform about that. The other ones deal with certain specific aspects, and I will further discuss this in the paper in terms of timing. I think that is the better solution. Maybe we can go to my next slide. Well, I propose that I will just skip this part on the CRD, except if you allow me to further deal with this. But I think the more important aspect is this last part, where I want to say a few more things on the general perspective towards more sustainable consumer law. There's a lot to say about the current proposal. I think there's a lot of criticism to be formulated, and certainly also I think in the European Parliament it's already clear that the proposal does not live up to the expectations of the European Parliament in terms of earlier Parliament resolutions in relation to repairability information, durability, expected lifetime information, fight against premature obsolescence. Also, the stakes are high. We need to recalibrate consumer law. We need to integrate sustainability considerations. Please, on the next slide, I think we should not longer merely weigh economic interests of happy consumers and happy traders, but go beyond and find an equilibrium that takes also care of those externalities. On the next slide, time is now. Consumer law alone cannot do this, and I think it's clearly evident also from the thesis that will be defended tomorrow, that consumer law is not isolated and is heavily linked also, and should be linked much more with product legislation and waste law. So this rebooted consumer law has a major role to play together with other legal fields. End of silo thinking, out of box thinking. And then the last slide gives you an overview, I think, of various other papers and contributions that we've already done, and some of them were also published, I think, in your journal. And thank you for that. And the next slide shows the image of the defense of Anaïs Michel. The commercial edition of her book will soon follow. Thank you so much. I hope it was not too long.
Thank you so much, Bert. I think that's a topic that would be worth for an even longer presentation, and we're very much looking forward to the written contribution on this very fundamental change, this transition of consumer law, this reconceptualization of consumer welfare, and the very societal purpose of consumer law in the green transition. And so our next speaker will also address the green transition and the role of European private law in this fundamental change. And I have the pleasure to introduce Francesca Bertelli. She's a postdoc researcher at the University La Sapienza in Rome, where she is focusing on private law, corporate social responsibility, sustainability, and the implications on consumer law and capital markets law. She published a book on the Dieselgate scandal in 2021, a topic which has also been dealt with in our journal. And in this year, she published another monograph on the enforceability of sustainability claims under the Consumer Sales Directive. Francesca, we're very much looking forward to your presentation.
Thanks, Professor Bush, and thanks to Professor De Franceschi and to all the board of editors for the opportunity of being here with you, sharing my thoughts with such an amazing group of experts. And I will also try to share my presentation. Just let me know if you can see it, please. Can you see it?
Yes, we can see it. Excellent.
So the title of my presentation starts from one of the main points Professor Sterniak in the first presentation has already touched. We need responsible traders and consumers who are aware of their rights in the market. So that's my starting point. I do believe that a cultural change could promote more sustainable behaviors of market players, who are, in my opinion, the real drivers of sustainable development. And in this scenario, I do believe that the achievement of an active market citizenship leading this process of transition is possible through information or through correct informational flows. Transparency, in my opinion, as a rebalancing power in a symmetric relationship, but also on market dynamics overall. But without running so fast to my conclusion starting from the title, I will start with a brief summary trying to explain the path I'm going to follow to answer to one simple question: how and to what extent private law and European private law could serve the goal of market citizenship. I will start highlighting that the principle of sustainable development is already included in European law as well as in national constitution. I will then focus on the 17th Sustainable Development Goal, the systemic goal, namely partnership for the goals, because this goal, once coordinated with a more targeted goal, responsible consumption and production, has major impacts on traditional paradigms of market law, an impact that can already be appreciated at institutional or structural, corporate, and consumption level. The main lines of the European Green Deal immediately highlight the areas driven by private law or regulatory private law, driving the transition towards a circular economy and the network of existing connections between them. And in this scenario, sustainability, in my opinion, is ceasing to be a weak concept, and its function, the function of the principle of sustainable development, is becoming less and less blurred. EU treaties, national constitution are already referring to the principle of sustainable development as a principle of postmodern law. And this reference to the principle is becoming explicit sometimes in modern constitutions. Just consider, for instance, the paragraph 20A of the German Grundgesetz, recalling states' responsibility to a future generation in the protection of foundation of human rights and animals, and in ensuring the enforcement of connected human rights within the constitutional order. Also consider la Charte de l'Environnement Français, but also the Italian Constitution, especially the provisions of Articles 9 and 41, as recently amended. Article 41 now foresees banding boundaries for private economic initiative, also related to the environment. But the reference to the roots of the principle of sustainable development are in constitutional common values. And that's why if we adopt a human-centered approach, we must consider the environment simply as a component of the human dignity overall. And sustainable development in this perspective synthesizes constitutional common values, such as first and foremost, solidarity. What has changed then since the entry into force of national constitutions? A renewed awareness. The awareness that an economic growth threatening the environment and thus addressing societal issues will not permit the ongoing enjoyment of fundamental freedoms. And this consideration requires and determines a different approach to the concept of development itself. The economic model of the EU of an economic, competitive, social market economy, as well as the overall approach to EU law, are now under transformation. EU policies, after decades spent focusing on market regulation to ensure free competition, are now adopting strategies and measures aimed at enhancing cooperation between institutions and market players, and more generally, at the empowerment of stakeholders. The principle of sustainable development demands of every market player a contribution for the transition to a circular economy. And this consideration is self-evident if we consider the scope of the 17th Sustainable Development Goal, Partnership for the Goal I already mentioned. This objective is clearly a goal itself, but however, Partnership for the Goals is also a mandatory condition to achieve all the indicators and targets of every Sustainable Development Goal. In this scenario, the Agenda 2030 clearly shows that sustainable development can only be achieved through new forms of cooperation beyond those between private parties. The private sector certainly still plays an important role in the market, but despite this, the required level of cooperation is a multi-level, multi-stakeholder, of course, in a cross-country dimension, but also in a cross-sector and multidimensional size. Intersections between the private and the public sphere are increasingly evident in capital market law. If we just consider the energy sector as well as banking and finance or the new technologies applied therein, we easily find clear examples. And these fields demonstrate that cooperation between institutional actors, private players, and public independent authorities is vital for the creation of a more balanced economic development, taking into account stakeholders' needs and interests. From this perspective, the goal of Partnership for the Goal certainly raises some questions concerning the rights and duties of corporations in the adaptation of their business models to address the environmental and social implications of their activities. Anyhow, once legal compliance is ensured, the choice of the less sustainable option still is and will probably always be an essential means of the economic freedom. And then we can have a problem because voluntary approaches to CSR have already revealed some inconsistencies. Nevertheless, I do believe that sustainable behavior could be encouraged by a virtuous circle of responsible consumption and production, a circle that requires to combine two components, consciousness and transparency. European behavioral studies concerning ethical and responsible consumption and investing attitudes assist us in understanding that sustainability information is determinant for an effective engagement of small market actors in the transition to a low-carbon economy. And on the one hand, nothing new to hear, easily accessible and clear non-financial disclosure will prevent market failures. Besides this, transparency would also ensure the empowerment of consumers and retail investors, unleashing their potential to express preferences for sustainable products, services, and companies. The awareness of ethical market players could drive this virtuous cycle for a more responsible consumption and production through demand and supply mechanisms. And in this context, the integration of environmental or social perspective, as well as ESG factors in private law instruments, primarily in contracts, will allow market players to express a political power through their private autonomy, and will allow them to push the economic model through sustainability. The importance of private initiatives in reshaping the economic model can already be appreciated at institutional level. Just consider, for instance, the importance of sustainability criteria in the Green Public Procurement Directive, or even more in the new taxonomy regulation. At structural level, the paradigm itself of regulation is also changing. This is, in my opinion, well testified by the new pilot regime for distributed ledger technology and by the sandbox approach adopted by the EU legislator. According to this approach, indeed, new forms of cooperation between market players and public authorities are vital for the creation of an efficient legal framework based on practical need, but also supported by consensus. Besides this, there are several major or ongoing initiatives highlighting the essential role of business in society and the ever-increasing engagement of corporations as key partners in development. And they all go beyond voluntary CSR approaches. And they can be supported by private law instruments. Just consider the possibility to enforce sustainability clauses in contracts of the supply chain, or to recognize the enforceability of codes of conduct. Probably the most significant ongoing measure will be the Corporate Sustainability Reporting Directive, which is currently under debate at the EU Parliament, but hopefully will come soon into force. Indeed, this Corporate Sustainability Reporting Directive aims at enshrining a duty for directors of EU companies to set up and oversee the implementation of corporate sustainability and to adapt company strategy to take into account ESG risk. It means that directors will be required to take into account the consequences of their decisions for sustainability, and that under certain conditions, unsustainable business behaviors will be a source of liability for corporation. And this has reflection both on CEO liability and CEO remuneration. Both these elements will give for sure a renewed awareness of stakeholders' interests in boardrooms, but I do believe that proper mechanisms to ensure this kind of engagement still need to be pointed out, and probably new technologies could help in this evaluation. Anyhow, without losing the focus to the core issue of my presentation, Corporate Sustainability Reporting Directive also seemed to strengthen the relationship between corporate governance and sustainability information / ethical consumption. And this profile, information and consumption, reconnects us to the 12th Sustainable Development Goal, which is responsible consumption and production. From the entrepreneurial side, this goal focuses on the positive outcomes of business on society. Outcomes which could be maximized by the identification of appropriate tools to encourage a corporate citizenship. Profit for corporation will always be a goal, and in this analysis, we must just consider data concerning sustainable attitudes in purchase and investing behaviors. The other side of Sustainable Development Goal 12, indeed, is consumption, and sustainable attitudes of consumers and retail investors, as demonstrated by data available at European and international level, immediately reveal how powerful, informed and conscious consumer could become on the market if the power imbalance caused by information asymmetry in business-to-consumer relationship was overcome. Sustainability disclosure then underlies the rebalancing power of information, which could be appreciated both in pathology and physiology of what we call sustainability claims. In the former, pathology, sustainability claims are already relevant since the communication to the public of deceptive or misleading sustainability information can be addressed invoking at first the UCPD Unfair Commercial Practices Directive and the MCAD Misleading and Comparative Advertising Directive. In my opinion, the recent proposal already mentioned in the previous presentation endorses this reconstruction. This proposal certainly has some flaws, but it specifically at least tackles greenwashing. On the one hand, as already mentioned, environmental or social impact as well as characteristics of the goods such as durability and reparability are enclosed in possible misleading product characteristics. On the other hand, the dissemination to the public of generic, vague environmental claims where the excellent performance of the product cannot be demonstrated is blacklisted as unfair commercial practice. But without overlapping with the previous presentation, a very interesting profile, in my opinion, depends on the fact that modification proposed for the Consumer Rights Directive aims at widening sellers' pre-contractual information duties to features of the products such as durability and reparability. It somehow nudges producer to realize long-lasting and repairable goods and challenges somehow planned obsolescence. But it isn't simply a nudging strategy, because pre-contractual duties also have implications on sellers' liability. Namely, in my opinion, the impact on the evaluation of conformity of the delivered goods. The objective criteria of conformity offered by the new Article 7, letter D of the Directive 771/2019 now explicitly include the reasonable expectation of the consumer based on public statements made by or on behalf of the seller or by other professionals in the value chain. As a consequence, the delivery of a good whose environmental qualities cannot be demonstrated or whose production threatens human rights or the environment should determine seller's liability to the consumer for a lack of conformity. In this context, the context of the Consumer Sale of Goods Directive, please allow a very brief reference to the framing of Article 13 of the directive, regulating the hierarchy of remedies for the lack of conformity. Under the light of the principle of sustainable development, repair could become the most sustainable remedy overall, capable of balancing consumers' interest to achieve the planned utility, sellers' interest to maintain the contractual relationship, with the more general interest to incentivize sustainable production. Going to my conclusion, given that the power imbalance in business-to-consumer relationship depends on the availability of information, it is therefore possible that transparency will redistribute power in the market. The flow of information in the right direction is indeed functional to empower stakeholders and to promote directive citizenship. So it's functional to make overall market more democratic. In this virtuous cycle of responsible consumption and production, a dialogical relationship between stakeholders and corporations could make the adoption of sustainable business model the most sustainable choice also from an economic perspective. And what I'm trying to say is that we already have some legal instruments fostering and supporting transparency and thus empowering conscious consumer to incentivize sustainable business. The Corporate Sustainability Reporting Directive will cover the supply chain going back to the source of raw materials. It will also cover production and manufacturing, as well as distribution, a field in which I do believe that the role of standards of the World Trade Organization should be also further explored. The Corporate Sustainability Reporting Directive will also cover partially consumption, at least for the profiles concerning policies adopted to ensure products' durability and repairability. Consumption is then the privileged addressee of the UCPD and the Consumer Rights Directive, as well as the Consumer Sale of Goods Directive, according to which, as I tried to explain, sustainability information must be considered relevant and connected to enforceable consumer rights. Additionally, the planned introduction of eco-design for sustainable products and labeling for sustainability could hopefully help in providing easily accessible information to the consumer and thus facilitate sustainable choices. Under these slides, I do believe that the image of the weak consumer as such, the addressee of measure of protection must be reconceptualized. The aware, informed consumer, as a market citizen, could have the political rights and the duty to shape market dynamics through the expression of one of its fundamental freedom, which is, in the case in point, private autonomy. Thanks for your attention.
Thank you so much, Francesca, for your presentation. And this brings us to our final speaker, and that is Rolf Weber, who is a professor emeritus at the University of Zurich in Switzerland. He's a member of the appeals board of the Swiss Stock Exchange and also a member of the Center for Information Society and Law at the University of Zurich. And I'm glad to add he's a long-standing supporter of our journal. He will speak about one of the eternal topics of EU consumer law, the information model, you could say, in a sense, the holy grail of EU consumer law, how to rejuvenate the information model. We will have a full session on this after the coffee break, but Professor Weber already introduces us to this great topic. I'm looking forward to your presentation.
Well, thank you very much, Christopher, for the nice introductory words. Do you see my slides?
Yes, we can see them.
Okay, excellent. First of all, congratulations to the journal, and of course also congratulations to Alberto. And I'm really sorry, Alberto, that you cannot spend the whole day in spending a nice time with your family for your birthday, but somehow you have chosen the date. As it has been said in the introduction, I would like to have a critical look at the present situation as far as disclosure and transparency, as well as information requirements in EU consumer law is concerned. And I'm glad to start with a quote of Hans Micklitz, who is also amongst us. He convincingly wrote recently in the journal, I quote, "It can no longer be taken for granted that fully harmonized consumer law provides for the best solution." And I would like to transpose this very valuable sentence to the field of disclosure and information requirements. Indeed, the Consumer Rights Directive and the new deal for consumer has intensively implemented information requirements, and the same is also true in newer instruments, for example, the Digital Contract Law Directives 2019-770 and 771, as well as the online platform regulation. All these legal instruments envisage to achieve a high consumer protection level by implementing rules-based minimum standards. I use this term now and will then distinguish from a more principles-based approach. Information requirements are in principle designed to help consumers to make reasonable decisions. This approach has in fact been pursued over the last decade, notwithstanding the fact that at least in academic circles, some skepticism has been expressed as far as mandated disclosure is concerned, and I'm coming to that in a few minutes. What are the main potential instruments in EU consumer law? We do have specific, partly limited prohibitions in form of behavioral bans. Then we do have the information requirements, the topic of my short presentation. We do have restrictions on general business terms, content related restrictions, and specific control and supervision measure. I may just add here, since I'm coming from a country not being member of the European Union, our restrictions in Swiss law are much more lenient than the restrictions in EU consumer law. And then we have rules on the burden of proof and liability, making the enforcement of damage claims easier for consumers. Why do we have all these rules? Usually it is said that the consumer is a weaker contract party, and therefore he or she merits specific protection. And the second point, being more relevant now for my presentation, says the structural information asymmetries between the market participants jeopardize the efficient allocation of economic resources.
Sorry to interrupt you, Professor Weber. We still see the first slide of your presentation. I assume that you would want to
yeah, of course. I'm somehow really now a little bit embarrassed that it doesn't move. Perhaps Alberto, could you perhaps share the slides if I'm somehow blocked? Or
yes,
do you see now slide 4 or still slide 2?
I'm sure Alberto can
okay.
this.
Sorry for that, but since we are anyhow quite far advanced in time, I nevertheless continue. I'm on now with slide number 4. Thank you very much, Alberto. The paradigm of mandated disclosure, which should counterweigh the assumed information asymmetries, even if the asymmetries exist, which is at least not very clear in digital markets, or it should be discussed in more detail. And even if it can be argued that mandated disclosure is not the traditional paternalistic approach, since the consumer does not become the beneficiary of specific behavioral requirements. Objections against mandated disclosure raised in academic research should be taken serious and merit to be discussed in more detail. It is true that the main literature on this paradigm has been published in relation to financial market regulations. However, it does make sense to apply somehow a cross-field perspective and take experiences which have been made in financial market regulation, also serious in the field of consumer law. And so far, if we look at the literature which was published partly in the United States, but also in Europe, then we learn that we do have hidden costs caused by mandated disclosure. And we also have objections which go into the direction of exacerbated inequality, of impairing consumer decisions, and deter lawmakers from adopting better regulation. I'm conscious of the fact that I put now a step into the law and economics room of Rupert Potsdam, and I will withdraw this step immediately. But this appears to me field to be a field which should be more carefully considered, and I just may quote one of the authors having published and done intensive research on this field, namely Benjar and Schneider, arguing that the provided information, whether individually aggregated or based on advice, I quote, will not adequately help the naives in their dealings with the sophisticated. Obviously, I'm not at all a academic who does not see the merits of transparency. In contrast, I've done a lot of work in the transparency field so far, perhaps a little bit less in consumer law, but much more, for example, in the context of internet governance. But I really think that we should try to develop a new understanding of transparency and try to avoid some challenges caused by the present relations and look for a new concept. This leads me to slide 5. We do have challenges with the disclosure paradigm. Looking from a societal perspective, too much transparency could have two negative effects. The sheer volume and intensity of information leads to a confusion effect, since the consumers are not anymore able to cope with all the information, details, and lose the necessary overview of the data. And the permanent delivery of similar information causes a Cassandra effect. Even if consumers take note of the information, its contents is no longer seen as being reliable. And the general wisdom that overconsumption of information can have negative effects is not even very new. For example, already Niklas Luhmann argued that over-information consumes working and leisure time on the supplier and the consumer side. Attention is a scarce resource. A person cannot dispose of its resource in an unlimited way, and the utilization level of the potential informational supply is decreasing in case of data overload. And the second main challenge, in fact, is overconfidence. I would like to be short on that. My thoughts here are based on psychological studies, mainly done by Nobel laureate Kahneman, arguing, for example, that the majority of people is of the opinion to be above average as far as capabilities are concerned. Also, of course, only half can really be. And overconfidence, and that's my point in the context of disclosure requirements, has the tendency, based on these psychological studies, to overestimate the benefits due to the overwhelming information. And this leads me now to my key message. How could an improved transparency concept look like? Next slide, please. The provision of better transparency and adequate access to information, but also the establishment of a possible direct participation in policy making is imperative in the consumer field. So the importance of transparency is not at all contested from my side, in particular because improved transparency can contribute to the empowerment of consumer, and that's probably my key thought in this context. Transparency should also address the way how information is delivered in order to optimize the outcome of the information process. So I think that we should look more deeply into procedural aspects and also the way how consumers really receive and deal and work with the information. Often the source of the transparency problem is not grounded in disclosure requirements, but in the way how individuals filter information. Therefore, salience matters when certain information is essential for the individual or for general welfare. And in this context, I would like to refer to a transparency provision which is contained in the GDPR, namely in Article 12. According to this provision, information must be given, and I quote again, in a concise, transparent, intelligible, and easily accessible form using clear and plain language. I'm of the opinion that this quite short sentence is equally valuable for EU consumer law in general. And furthermore, as I mentioned at the very beginning, I would also advocate for trying to come to a more principles-based approach, trying to implement only some minimal harmonization standards and go a little bit away from the rules-based approach. A general framework can facilitate the attempt to concentrate on the quality of regulation instead of its quantity, since less is often more. And this leads me then to the last slide. A future-oriented understanding of an appropriate transparency concept should observe a couple of elements. The information recipient must be seen as a right holder and an essential component for the perception of both information and transparency. Secondly, publicly reliable information must be provided. In other words, reliable information means substantive quality standards supported by an adequate procedural framework which influences people's choice, since a rational person would arguably organize his or her conduct in accordance with law. And thirdly, disclosure procedures must be available and be observed. In other words, transparency implies constant visibility of the sources of information. Improved transparency needs to contribute to the empowerment of consumers. Therefore, information recipients, consumers, are to be seen as rights holders, but also as stakeholders in the production and in the use of information. The substantive quality standards should induce people to organize their conduct in accordance with the legal framework, and disclosure procedures need to be available. In a nutshell, forward-looking lawmakers should recognize that less is often more, and that quality is more important than quantity. And I would like to reword the sentence of Hans Micklitz, which I quoted at the beginning, to a certain extent, hopefully without violating his copyright. In fact, I would say it can no longer be taken for granted that fully harmonized rules-based consumer information and transparency law provides for the best solution. Thank you very much.
Thank you very much, Rolf Weber, for this presentation, which was concise, clear, and easily accessible, to use the phrase that you have used. Thank you very much to all speakers. Unfortunately, I have to leave you now, but I can leave you in the able hands of Alberto De Franceschi, who has kindly agreed to chair the discussion. So thank you very much again to all speakers, and enjoy the EUCML conference.
Thank you very much, Christoph, for chairing the session. And thank you so much to all the speakers for their brilliant presentation, really enlightened on many overarching issues and challenges in EU consumer market law. Now we have 10 minutes for discussion, 12 minutes for precision, and I would like to open the floor for those of you who would like to participate in the discussion. Please raise your virtual hand, the function you see at the bottom of your screen, or write in the chat as you prefer. I see a first question in the chat by Rita Simon. Bert Keswick already answered in the chat. Perhaps you would like to add something to what he wrote, or to elaborate. So the question was, thank you, Bert, for the excellent summary. May I ask your opinion with the sustainability consumer policy, why the sustainability consumer policy is so reluctant to nudge consumers towards more sustainable behavior? For instance, obligation to repair instead of some rights.
Well, yes, I think the essence of my answer was already in the chat. I think it's a paradigm shift for consumer law, and it will be difficult. It will be difficult at both sides, so to speak, at the business side and at the consumer side as well. So that is the main takeaway point. There's 3 incoming presidencies who will work on those proposals. I expect that it will be very difficult trialogues. And I hope that the outputs will be readable and make sense and make a difference. But Hans also had a question, I think.
Yes, thank you, Bert. And now the floor to Hans, who is also a member of our advisory board and one of our excellent authors. So please, Hans, you have the floor.
Yeah, thank you all for the for the great opening. It was a wonderful large array of issues, from conceptual quants to digitization to sustainability to transparency and information. And I would like only to stress one point here that former Advocate General Trestniak also mentioned. I think it is absolutely crucial that wherever we are going, that we start from a solid theoretical ground. I think the risk is to cherry pick and go here and there in one direction, focus on one tool or on this tool. But I think consumer law needs a new direction, and that direction must be guided by a solid understanding of the theoretical function of consumer law that is now, let's say, freed from its silo thinking and reintegrated into a much broader concept that unites economic and non-economic issues and private law and constitution. And yeah, that's it. That's my major message. So I think here we have to work on, and that will help us also in finding possible solutions when it comes to concretize issues like information or transparency, just to cherry pick on one, or reporting duties of corporate companies. Thank you.
Thank you very much, Hans. very much agree with you. And if any one of the speakers would like to react to this statement, there is space.
Well, perhaps I couldn't agree more if I may just add a sentence to the statement made by Hans. But I think it would also mean that at the universities, we are going to review the drawer system which we have used for the last 100 years. Consumer law requires to have knowledge in many different traditional legal fields, from private law, as Hans said, over constitutional law to criminal law, and we really need to overcome the vertical distinctions which we make at faculties and go into the direction of a horizontal perspective.
Thank you. Rolf, we have a question by Emilia Misenic.
Yeah, thank you very much, Alberto. Can you hear me?
Yes, perfectly. Thank you, Emilia.
Okay. I was actually quite impressed by Professor Weber's lecture, although I was able just to hear the last part because I came just back from my lectures. But I think I already Hans took a part of my thoughts. I was actually wondering how we would, what do you think, Professor Weber, in which way or how we should approach to strengthen the transparency, and what would be possible? I know it's a difficult question. What would be legislative approach, let's say, at the EU level to improve this current situation? Because on the one hand, we have this huge information overload across different EU directives. On the other hand, in practice, we see by just checking Commission SWAPE actions that it's not functioning. Yes. So, I mean, also with digitalization that we listened in the morning and smart contracts and everything, I believe that this affects transparency significantly. Yeah, there are many, of course, doubts whether this instrument is so important. And I think, as Professor Miklitz said, we should be focused not only on one instrument, but when it comes to information duties and transparency, what is your opinion? Should we go for less information that would be, let's say, essential ones in order not to confuse consumers? Or thank you so much.
Well, thank you very much for the question. Unfortunately, I do not have the solution. If I had reached some final conclusion, I had certainly presented these conclusions on my last slide. I'm of the opinion that we should try to change a little bit the regulatory approach as it has been chosen by the European Commission for the last maybe 10 years. And we should try to come away from a rules-based approach, being approach which tries to implement certain regulatory objectives in a very detailed way, and go over to a more principles-based approach, which obviously has to be founded on theoretical insights which we gain from further academic research. And if we apply a more principles-based approach, and this means we just say in principle which information should be delivered and how procedurally disclosure must be made. We do have more flexibility in concretizing than the details of the information requirements, so to speak, on the spot or depending on a specific field of consumer law. and we would not be obliged to expect from the consumers to go through very, very long lists of information requirements, what they are anyhow not doing. But as I said, unfortunately, I do not yet have somehow the final conclusion. I just wanted to play the ball, so to speak, into this round of excellent speakers and participants, and hopefully somebody takes up the ball.
Thank you very much, Wolf. And there is a question by Bert Kasper. Please, Bert.
Yes, I just wanted to quickly react to what Hans said. I cannot agree more. Of course, that was also the point they made at the end of the speech. Of course, it's interesting to make general policy recommendations in order to make consumer law more sustainable. It's also, of course, intellectually interesting to make technical remarks in relation to Commission proposals put at the table. But what is really interesting and really needed also is to do theory building, and again to reconsider also the goals of consumer protection law, of consumer law. There has been some early attempts already back in the late 90s with papers, for example, by Thomas Wilhelmsen on the relation between consumer protection and environmental protection. Environmental protection, that's one of the horizontal clauses also, Article 1 TFEU. So this is really an exercise that should be done. And then you have a kind of compass, you have a kind of vision that can steer the institutions in drafting the new laws that make a new balance. Without that, I agree, it will be a combi of quick wins and cherry picking and maybe some symbolic legislation, but with no real impact on making the shift.
I think, if I may, I think there is an elephant in the room, and I would like to address it.
Mm-hmm.
That is, what are the responsibilities of the consumer?
Mm-hmm.
Yeah, we have spoken 60 years about rights. Yeah. Let us now think about responsibilities. In particular, when we link it to something like market citizenship. Yeah. So when we introduce the political dimension to consumption.
Mm-hmm. That's true. That was also mentioned by Francesca in her speech, and I think also in my reply in the chat.
Yes, I saw it. I saw it. Yeah, I agree.
Imposing consumer obligations. Yeah. Just a thought.
So thank you very much. I am glad to see that from the overarching challenges, we are shifting to the overarching goals, which is very virtuous and very productive. Questions?
We could not hear you well.
So, no other questions. I would like to thank all the excellent speakers who opened this conference, and I would like to, and also those who took part in this fruitful discussion. And we will resume. We will now have 10 minutes coffee break, and we will resume at 11:20. Thank you very much.
Okay, I think we will slowly start to keep on time. Thank you everyone again for joining us and rejoining us for the second panel. As Christoph has already mentioned, we kind of had an introduction to this panel already with the introduction of Professor Weber with his presentation on transparency and the importance of it. But actually, if we look back at all the presentations in the first session, almost everyone in it mentioned importance of information, whether for the purposes of avoiding greenwashing or for the purposes of understanding smart contracts or importance of education of consumers. So I think this brings us to this paradox that we keep on encountering with information being seen as a very important tool in the empowerment of consumers and in the consumer protection, while at the same time, almost all of us, I think, on this call, one way or another, criticize the information tools and lack of effectiveness of information obligations. Now, in this session that focuses on the functionality of the information model and pre-contractual information, we hope to hear more from our speakers on different new developments around pre-contractual information obligations and different areas where there is potentially an improvement, hopefully, in how enforcement of these obligations and how empowerment by the information of consumers works. And we will start with Michela Ciancimino, who's our first speaker in this panel, who's a research fellow at LUMSA University in Palermo in the Department of Law there. Michel has, during his PhD studies, research data protection, and especially in healthcare. And recently, he has published actually part of his research findings in our journal in an article on AI-based decision-making in healthcare, where he argued for more consistent approach to the protection of and processing of personal data. But today, I think you're moving towards like your new research interest in information obligations, and you will discuss with us adequacy and effectiveness of pre-contractual information duties in car flexible finance agreements. So welcome, the floor is to you.
Thank you. Can you hear me?
Yes, we can hear you well.
Okay. Well, can you see my PowerPoint?
Yes, that works.
Okay. Well, good morning, everyone. First of all, I would like to thank our editors for this great opportunity. My presentation will concern the adequacy of advertising and pre-contractual information in car flexible finance agreements. Nowadays, financing is one of the most common ways of buying new cars. More recently, some car companies have started to offer consumers special lease contracts with a redemption option. These are quite complex offers due to the inclusion of different elements: an upfront payment, several monthly installments, maxi final installment, or a redemption value, which allows different distribution of payments over time. In this regard, the Italian Competition and Market Authority has closed by accepting the proposed commitments. 14 proceedings started against the main car producers operating in Italy. According to the authority, the way in which the purchase with financing and leasing offers were presented was in fact both omissive and misleading. And because essential information concerning the cost to be borne was relegated in sections not easy to read. Indeed, one wonders what the possible civil law consequences might be when the breach of these duties arises on the substantial level, on the direct comprehensibility of such information. By the way, first of all, understanding the specific case in point would be useful. As said before, looking at the Italian framework, car financing opportunities have become increasingly popular in recent years. Consider, for instance, lease contracts and long-term rental. In addition to these, there are also typical forms of loans which can be defined as flexible finance contracts. So, as you know, a lease contract refers to that agreement whereby an economic subject obtains the availability for a certain period of time, and beside the payment of periodic installments of a car, reserving at the same time the right on expiry to return it or to acquire the ownership by paying an amount agreed in the contract. Similar to this model is the long-term rental. Here, in exchange for a periodic fee, the party obtains the availability of a vehicle or a car fleet where the grantor ensures all necessary services such as maintenance, insurance policies, and so on. Such choices also certain peculiarities from a fiscal point of view. Therefore, a careful wording of the agreement is relevant for optimizing the tax burden. Lastly, reference must be made to flexible financing contracts, a sort of hybrid between ordinary loans and lease. New ways of financing cars are arising in recent years, such as personal contract purchase, personal contract hire, or hire and purchase, and so on. These are customized form of finalized credit. Here, the user, usually a consumer, is asked, once he has identified the car he wishes to buy, to indicate the amount of the advance money he intends to pay, the average number of miles he intends to drive per year, and the duration of the installment plan, usually 3 years. On the basis of this information, the unit cost of the deposit and the amount of the final installment is calculated. The peculiarity in this case is that the customer, at the end of the contract, is allowed as an alternative to paying the final installment, which usually closes the financing, either to return the car or to replace the car with a new one. In the last case, the renewal, the final value of the car is counted as a new initial installment, and the contract starts again, and so on, potentially indefinitely. This explains the reasons for the success of this contractual formula. On the one hand, the user has the chance to buy a new car with a loan that usually has not very high interest rates, as it is offered by financial companies linked to the car manufacturer. The financing has an average, not excessively long duration, thus he has the possibility of obtaining ownership of the car in almost 3 years. Additional services such as routine maintenance are often included in the package to enable the car to maintain its final value. Finally, the chance of choosing between ending the financing, returning the vehicle, or replacing it with a new one offers the consumers greater flexibility, which is particularly convenient in situations of uncertainty about future needs. On the other hand, for the car company, this formula has several economic advantages. In fact, part of the profit comes from the interest rates paid, as well from the additional services included in the offer. In addition, since the user is usually encouraged to maintain the car well in order to benefit from the full guaranteed future value at the end of the 3 years, the car company has the possibility of being supplied with excellent second-hand cars. So from a legal point of view, this formula looks like a mixed contract with features of purchase, rental, and supply of services. This is an unusual item which raises several legal questions. For example, is the possibility of renewal the exercise of an alternative obligation, or is it an novation of the object, or is it a renegotiation of the contract? Well, I know these questions would deserve a specific examination, but they are not the specific subject of this speech. Actually, as anticipated before, the type of financing has been the subject of analyzed by the Italian Competition and Market Authority. The authority analyzed the personal contract purchase offers made by 14 car companies in Italy. The subject of their proceedings, however, did not concern the flexibility formula in itself, but rather the provision of clear information to consumers. The proceeding originated from a report by Codacons, an Italian consumer protection association. Codacons actually drew the authorities' attention to the fact that the advertising campaigns mainly presented the cost of the monthly installments, while they overlooked the amount of the upfront payment and of the final installment. This information, in fact, was relegated to section not easy to read, the content of which could only be viewed following one or more actions on the part of the consumer, clicking on one or more links, scrolling to the bottom of a page, enlarging the font, and so on. So, because of the opening of the investigation, the companies, while considering their advertising practices to be lawful, clear, and understandable, submitted proposals for commitments, kind of an ADR procedure for minor relevance cases. Among the measures proposed by companies, we can list the clear indication on the first contact web page of the main elements characterizing the PCP offer, and more specifically, the amount of the monthly fee, length, the amount of the advance, the term of validity of the offer, and also the provision of guidelines for the communication of financing and rental offers. In the Italian case, the authority, deeming the practice not excessively serious, allowed the conclusion of deals with car companies without adopting sanctioning measures. In this way, the authority obtained from the car companies the task to stop the breach. So, the examination of these features, I believe, leads to deepen the role of information disclosure in private law. Well, in my opinion, it is interesting to reflect on the contract concluded with the consumer following similar practices. Of course, I know the contribution will be more detailed of this speech. So in the present case, I believe the advertising stage is really close to the fulfillment of pre-contractual information duties. For the authority, in fact, it is the moment of the first contact that is relevant. So the professional is called to immediately provide all the essential information needed to understand at least the way of determining the price and the possible overall amount. So the commitments avoided every penalty measures. So the question that arises is, does the omission of this essential information have civil law consequences? In this regard, Italian scholars have found several possible solutions. So, according to a first theory, the omission of information may be qualified as unfair commercial practices, but it does not affect the validity of the agreement. Therefore, under this perspective, the contract could be voidable on the ground of defect of consent, so fraud or mistake. According to another approach, the chance of having the contract declared void for breach of mandatory rules will have to be assessed on a case-by-case evaluation. So, the sanction will have to be determined on the basis of the concrete peculiarities of the breach. Further, on the other hand, the Supreme Court tends to reject the idea that legally foreseen pre-contractual issues can invalidate the contract in absence of express provisions, preferring to evaluate the liability of the business trader. Nevertheless, for years, a part of the scholar has criticized this approach. However, for the consumer code, implementation of the Consumer Rights Directive, when intermediary violates pre-contractual information duties in such a way as to significantly modify the representation of the characteristics of the service, the agreement could be void. Concretely here, the aforesaid practice, I believe, is more misleading for the occasional consumer, perhaps not very familiar with financial practices, than for the average consumer who tends to buy a car after a long comparison of the available offers. But is this a significant alteration of the characteristics of the service as required by the Italian Consumer Code for the nullity of the agreement? Moreover, flexible financing agreements have been widespread, at least in Italy, for almost a decade. So it is fair to assume, in my opinion, that an attractive price stimulates the average consumer to investigate in depth the contractual terms. Of course, we have to concretely evaluate the validity of the contract in the light of consent of the single buyer. These considerations lead one to believe that the specific misbehavior, potentially unlawful at the level of public enforcement, is unlikely to have an impact on the negotiation regulation by its uncommon suitability to affect the will of the contracting parties. So, thank you for your attention. I hope to analyze in depth these aspects on the contribution.
Thank you, Michele, for providing these interesting insights from an Italian perspective on a very complex market. And I know it's a complex market because I recently had to look into options for financing a car. And even as an average consumer, I would say it's difficult to always get transparency as to what's being offered by whom in that market. Now, we'll come back to your presentation and the discussion, but first we'll have our second speakers, and it's two speakers that are joining us to discuss and present to us some insights from the Dutch perspective on pre-contractual information. So we have with us Professor Charlotte Pavillon from the University of Groningen, and Leonika Tichelaar, also from University of Groningen, assistant professor at the same university. You both obviously do a lot of research on consumer law, have recently also published with us in the EU-CML an article on the topic you will be presenting to us today, so the ex officio enforcement of information duties of the Consumer Rights Directive by the Dutch courts. And I'm looking forward to your presentation.
Thank you, Joasja, and thank you to the editorial board of EU-CML for organizing this conference. It's a great way to celebrate the 10th anniversary, and we would like to congratulate you all for making this journal so successful. Today, we are going to tell you a little bit more about how the CRD, the Consumer Rights Directive, is being enforced by the Dutch judiciary. It's a very interesting topic because our Supreme Court has really sees a role for itself as the guardian of consumer rights, as it seems, in the Netherlands. So, and we would like to discuss with you today whether it goes too far, or whether this is actually the right, just the right level of protection, like we discuss in the paper, which has indeed already been published. We are very honored that that has been the case. So thank you, Leonika. She has uploaded a presentation, and I'll give her the floor in a few slides, but I'll just start telling you a little bit about the Dutch procedural context of this this paper. Slide 1, maybe, Leonika. The possibility for Dutch courts. I still see slide 1, slide 2, maybe. I still see Yeah, thank you. There is a possibility for lower courts in the Netherlands to refer to the Supreme Court, to the Dutch Supreme Court, for a preliminary ruling. So if you have doubts about how to interpret national law, and this also goes for national law that implements European directives, you can ask the Dutch Supreme Court for a preliminary ruling. So it's actually the same approach as in Europe, but the cases in which this is possible are a little bit more limited. It's in cases where, for example, there are many cases dealing with the same or similar facts. And this is actually a set of questions that regards the ex officio application of the CRD in default cases. Leonieke will tell you a little bit more about what kind of cases it concerns. But just to start with, the Supreme Court has ruled, without referring to the Court of Justice, that national courts can be obliged to assess compliance with the CRD of their own motion. And if a sufficiently serious breach of one of more material or essential information duties has occurred, a national court has to fully or partially nullify the contract, whereby the partial nullification is the standard sanction or standard remedy in a default case, and it amounts to a price reduction. So this goes very, very far, because this concerns thousands of cases on a yearly basis. Slide 3. In its decision, in its ruling, our Supreme Court approaches remedies as sanctions. And this is actually a very interesting aspect of this whole enforcement by the judiciary in the Netherlands. The Article 24 in the CRD is titled sanctions, but it also it is applicable to remedies in the Netherlands, because we don't talk about penalties, we talk about sanctions. And sanctions is actually a broad concept encompassing both remedies and penalties. So this is actually a little bit lost in translation maybe, but there are different views on how to apply Article 24 to civil law remedies. But in the Netherlands, actually, civil law remedies view from the perspective of traders, of the infringer, and view from the perspective of the public interest of consumer law enforcement are viewed as sanctions. So a price reduction is actually both a remedy and a sanction under Dutch law, which means that the requirement of deterrence also applies to a remedy such as price reduction. And this explains a lot, I think. Why is this ruling interesting, I think, from a European point of view, and for the listeners today, is because many information duties in the CRD are not linked to a specific remedy. And this ruling also provides some insights on how national courts in the Netherlands, in this case, are dealing with their remedial autonomy. And there you see a lot of the divergence, I think, at the European level, and this is actually a indicative of a lack of harmonization on the level of remedies and sanctions. On slide 4, you can see a brief overview of the different articles that are relevant to this ruling. The information duties laid down in the CRD, Article 6, and the provisions in the Dutch Civil Code where these articles have been implemented. Article 8 on the formal requirements of information duties have been implemented in the Dutch Civil Code as well. The remedial autonomy has not been implemented. Of course, it's more a procedural type of article, but we also have transposed all the specific remedies laid down in the directive. But we fall back on our general nullity ground in the Dutch Civil Code to remedy, to sanction breaches of information duties. But what is very interesting to our presentation as well is that back in the day, in 2014, we already implemented the new remedies under the Unfair Commercial Practices Directive. The Modernization Directive has introduced a few remedies for consumers, like price reduction, ending the rescission of the contract, or damages. We already had those remedies available to our consumers since 2014, and we have this nullification ground for unfair commercial practices in our civil code as well. So there's this interesting link with misleading omissions and breaches of information duties laid down in the CRD, which will be analyzed further by Leonieke. So I'll give her the floor for the next slide.
Yes, thank you, Charlotte. Well, the two cases which led to the preliminary referral are illustrative for the bulk of cases reaching the courts, the lower courts, in which the consumer fails to pay a purchased product or a service. The first case concerns the online purchase of a shower panel. The consumer opted in this case for deferred payment, and the seller sent a confirmation email and delivered the shower panel. The consumer failed to pay the total amount of almost 170 euros and left this amount unpaid after several reminders of the seller. For that reason, the seller assigned the claim to a debt collection agency. The second case concerns an off-premises energy supply contract. The supplier provided the consumer with energy. The consumer, however, had a low to deadline for at least one invoice to expire and defaulted on payments despite reminders of the energy supplier. And also here in this case, the supplier assigned the claim to the debt collection agency. This is the key question of the preliminary referral. It consists of two parts. Should the lower court of its own motion verify, check whether a trader has complied with the information duties? And if there is a violation or a breach of those duties, what consequences should be attached to it? And the Supreme Court answers this question as follows. It starts with categorizing the information duties. And the Supreme Court does so by using the legal consequences attached to a violation. The first category contains information duties to which the Consumer Rights Directive attaches a specific sanction, like if the trader has not complied with the information duties on additional charges or other costs, or on the cost of returning the product in case of withdrawal. The consumer is not obliged to pay those costs and those charges. Another well-known example of a specific sanction is that in case the trader has not complied with the information on withdrawal, the withdrawal period will be extended with 12 months. The second category, information duties, contains those duties which the Consumer Rights Directive does not attach a specific sanction. One can think of the duty of the trader to reveal his identity and provide his address, or the obligation to notify the consumer about the minimum duration of the contract, especially important in case of an energy supply contract, like in the second case of this referral. And then we come to the, what's very important for this category is that, and Charlotte already mentioned that, the information has to be essential to fall into this category according to the Supreme Court. So, and it does not follow from the Consumer Rights Directive itself which information is deemed material. And therefore, the Supreme Court refers to another directive, and that's not surprisingly the Unfair Commercial Practices Directive. And information which is not material falls into the third category. And this covers legal information, like the reminder of the existence of the legal guarantee of conformity, codes of conduct, after-sale customer assistance, etc., etc. So the Supreme Court distinguishes 3 categories. And after that, the next step which the Supreme Court takes is that a court must examine ex officio whether it is sufficiently clear from the statements of the trader and the documents submitted to the court that the trader has complied with the duties of the first and the second category. And also whether the trader has respected the formal requirements around the disclosure of information, those very specific requirements regarding the clear and comprehensible manner of providing information. As far as the material information is concerned, the Supreme Court requires an ex officio application of a sanction when there has been a sufficiently serious breach. So after categorizing those information duties, the Supreme Court requires that a violation must be sufficiently serious for the ex officio application in case of the second category information duties. The ruling does not provide a concrete example of a sufficiently serious breach, but one can think, for example, you can think of the situation where a consumer is provided with a geographical address of the trader, but too late. So the geographical address is missing on the website of the web shop, but it is mentioned in the email confirmation. In view of the jurisprudence of the Court of Justice and its remedial autonomy, the Supreme Court deems not necessary the ex officio assessment of the remaining non-material information duties, the third category. So if the trader has not adhered to those first and second category information duties, the court must apply the specific sanction, or in case of the material information duties and a sufficiently serious breach, an effective, proportionate, and dissuasive sanction. So the sanction to be applied in case of the first category information duties, well, these are already specified in the Dutch Civil Code. Specific sanctions are implemented in our Dutch Civil Code by the copy and paste method. Relevant question is, of course, which sanction has to be applied in case of the second category information duties. In theory, several civil law sanctions can be suitable, but the Supreme Court discusses 2. Namely the book 3, the general nullification ground of Article 40 of our third book of our Dutch Civil Code, and Article 193J of Book 6 of our Dutch Civil Code. This last provision has been added to the Dutch Civil Code, and Charlotte already mentioned that. At the time of the transposition of the Consumer Rights Directive in 2014, and under this provision, a contract which has been concluded under the influence of an unfair commercial practice, including a misleading omission, is voidable. And this national provision has already acquired a European basis with the implementation of the Modernization Directive. Regarding the general nullification ground, the Supreme Court refers to the debate on the implementation of the Consumer Rights Directive. And this debate shows that the Dutch legislator considered, among other things, this provision, this general provision, as the ground of the nullification of the contract in case of a breach of one of those information duties of the Consumer Rights Directive. So the Supreme Court favors this highly protective Article 40 of the third book of a Dutch Civil Code, and it does so for practical reasons. This ground does not require that a breach of an information duty has affected the decision of the consumer to enter into a contract with the trader. And in line with that, the Supreme Court ruled that based on this provision, in case of a sufficiently serious breach of one or more of the material information duties, a court ought to nullify a distance or off-premises contract in whole or in part. And partial nullification of the contract may consist in a reduction of the consumer's payment obligations, while the consumer keeps the purchased good, like the shower panel in the first case. So this results in a price reduction for the consumer. This involves a great deal of work for the lower courts. And I think the Supreme Court furthermore pays attention in its ruling to some procedural obstacles, but I will not elaborate on that any further. But more interesting is that the Supreme Court makes a recommendation for the drafting of uniform guidelines to apply the price reduction. It underpins this proposal that uniform guidelines can enhance the practical applicability of the rules of the information duties at issue here and increase legal certainty. And the Supreme Court furthermore suggests that the judge may deviate from such a guideline in case, in particular, if the sanction provided for is not effective, proportionate, and dissuasive given the circumstances. Well, after the ruling, the Dutch Consumer Law Working Group devised a guidance document, and this committee has already issued several reports on the ex officio application of consumer law. And this guidance states 1 to 3 sufficiently serious violations of the information duty shall be sanctioned by a reduction of 25% of the principal amount due by the consumer, and more than 3 sufficiently serious breaches shall be sanctioned with a 50% reduction. Well, a glance at the judgments recently published on the Dutch database of the case law shows that, well, lower courts do apply that guideline. But it is striking that the reduction by half of the principal amount, the 50% reduction, is hardly applied in case law. Apparently, more than 3 serious violations do not occur very often. And in its ruling, the Supreme Court regularly mentions, and I also mentioned it a few times, the principles effectiveness, proportionality, and dissuasiveness. But the Supreme Court gives little direction to their interpretation. And the guideline, the adopted guideline, does not justify the chosen percentages on the basis of this threefold test, we call it. It's therefore not surprising that the lower courts rarely refer to those 3 principles, and when reviewing the percentages at hand by using the threefold test seems a bit too much for the lower courts. They never just mention it in their rulings. So, and I think with this last remark, I have already given you a lead in, I think.
Yeah.
Charlotte.
Thank you, Leonika. I'll be quick because I have one minute left. Yeah, I would like to comment a little bit on this ruling and the guidelines by the law courts, because it's very interesting in view of this threefold test. Does this choice of a price reduction where the consumer keeps the good, doesn't have to restitute anything, and also gets a price reduction while the consumer has defaulted in paying the price, is this a right signal? And at the same time, because it's civil law we're talking about here, is it also the approach that should be preferred? Because we really would like to stress that we also have a consumer and market authority who is applying penalties and who has a lot of public law remedies, possibility, means to enforce the Consumer Rights Directive. And So therefore, I think there is really a need for further alignment and to really coordinate their approach. All those lower courts applying the guidelines should coordinate their approach with the Consumer and Market Authority. So next slide, please, Leonike. I think we should ask ourselves a question: how should we deal with the deterrent effect of civil law remedies? And that's actually a European discussion as well, because if we look, for example, at the Representative Actions Directive, remedies are going to be applied, price reductions are going to be applied on a very large scale. And what does this mean in terms of remedying a harm caused to the consumer? Do we need to approach the harm in a very abstract way, like the court has done in the Netherlands, the Supreme Court, because there is no harm needed, there is no test whether the consumer has really been impacted, whether the consumer has been influenced by the lack of information. We don't know that. The court doesn't deem that important at all. So this is not really about remedies anymore. This is really about sanctioning the trader for violating consumer rights. So do we have enough guidance at European levels? Do civil courts actually have enough guidance to apply remedy in a deterrent way? Next slide, Leonike, please. The guideline and the high level of abstraction, the significant burden also on the law courts raises many questions in view of the threefold test. So this discussion is still ongoing in the Netherlands. At the end of January, there will be a big conference on how to change this practice, because this is actually really not working. This is very inefficient. This is bringing a lot of costs also for the judiciary, because this is an immense burden of workload for national courts. And at the same time, the fixed amounts of 25 and 50% are deemed quite high, actually, because, and is it even possible to translate a lack of information, an omission of material information into a percentage? That's a question as well, and it's actually quite arbitrary. Why 50%? Why 25%? And there are other consequences I have in mind, because at the moment we're also talking about Afterpay, Klarna, and all those buy now, pay later systems, which are qualified as consumer credit contracts. And if the rules have not been applied, the creditworthiness has not been applied, etc., would that mean that all the consumers who have bought something with Afterpay can keep the good and get 50% of their price back? And this is also having an ambulance chaser effect on claim organizations and collective claims. And we have this class action possibility in the Netherlands. So this is also having a real societal and impact also on that side. So last slide, please. We have also, with Leonike in our paper, suggested we fall back on the remedy in the Unfair Commercial Practices Directive for the sake of consistency as well. And we regret, that will be my last remark, that the Supreme Court hasn't forwarded the questions to the Court of Justice, just to be sure that there is enough consistency between the sanctioning of the CRD and the UCPD, because now we see, and this is actually very striking, that invoking a remedy for a breach of the UCPD is the threshold is much higher than having when there is a breach of a consumer information duty. The threshold is much lower. You get this price reduction, whereas if you're suffering from harm from a misleading practice, for example, you have to prove that you have concluded a contract under influence of the misleading practice. You have to show that there is that you have suffered harm, and that's not the case now for information duties, which are approached in a very formal way, and I'm not sure that has been the intention of the legislator back in 2011. So thank you, and I'm really curious about your remarks and suggestions. Thank you.
Thank you, Charlotte and Leonique, for that interesting presentation. I invite now our audience to ask questions, and I see that our fellow editor, Vanessa Mack, professor from University of Leiden, already has a question. So I'll give the floor to Vanessa and then to Emilia Micheniz.
Thank you, Joasja, and thank you for two very interesting presentations. My question is for Charlotte and Leonieke. So I think you gave a very clear presentation of the Dutch approach to sanctions for infringement of information duties under the CRD. And you also raised the question whether this is the way to go. And I think Charlotte already pointed out what concerns may arise. But you also said that there will be a conference where the alternatives to this approach will be discussed. And I'm wondering now also with the decision of the Supreme Court, what space is still left for alternative approaches in the Netherlands?
Yes, I'm wondering myself what they have in mind, because this is actually a conference organized by court bailiffs, because they are struggling as well with the amount of information they have to provide to the courts, for the courts to test ex officio whether all the information has been given, and the list of information duties is growing and growing and growing further and further and further. So it's becoming more and more complicated. They sometimes have like hundreds of pages of print screens to check whether all the information has been given at a given moment. So this is actually really not working. So they are thinking about maybe looking at a separate institution who is going to check whether a website at a certain moment in time has complied with the information duties, like a certification entity, which would look at this very complicated, because it's a checklist. Actually, they take Article 6 of the directive and they look at courts. They have all teams just checking, looking. Okay, is the name of the trader mentioned? Is this is amazing how much time is involved with checking this. So they think about maybe a separate organism who could look at entity who could look at this this compliance check. Yeah.
Okay, well, very interesting. And if I may respond.
I would prefer first maybe to give the floor to Emilia, and if there's time, Vanessa, I'll come back to you, okay?
Thank you so much. I also need to go back to my classes, so it's good that you gave the floor. I will try to be short, although I have comments for both presentation. Thank you so much, Charlotte, and if I may, Leonieke, yes, for this excellent lecture. I was actually quite pleased to hear that you have this double mechanism, let's say. We have it too, although we don't have such a legislative approach and, of course, this detailed Supreme Court analysis as you have it. But we came to some similar conclusion during our discussion on unfair contractual terms in credit agreements. So basically, when it comes to this complex duty of courts to check all this information, so we sort of all came to the same issue when it comes to courts, yes, because they also had to check all these information. So maybe this leads us back to the transparency and information duty and what we have to do differently so they would not have this how to say, billion informations to check. But I'm quite pleased with the double system. I mean, it's more effective because we have also this public law system that is in our country not functioning very well. We are always questioning, where are these guys sanctioning inspectors, as we call them in our country? You cannot see them anywhere. So I think this civil law mechanism is, at least my point, I was thrilled. I was quite pleased to see that. But I understand the part when it comes to civil procedure, and when it comes to the colleague, it's difficult. Michele, yes, or thank you so much. I was wondering. So you were telling us about the Italian case of the Consumer and Market Authority from what was the date July 2022, yes? And on consumer credits, these are consumer credits, yes? You were talking about car loans, yes? So basically, I think these pre-contractual information duties, they are covered, yes, by the Consumer Credit Directive. So I think you said there is a question whether there should be civil law sanction, as we have heard now from Charlotte and Leonike, when it comes to violation of information duties. So, and you mentioned that you are not sure about unfair commercial practices, but the answer could lie, as I said, again, we have this huge experience with credit agreements in the UCTD directive. Because if you are checking the unfair contract terms, of course, you have to check all the circumstances of the case, yes? If you check the unfairness. And of course, then in that case, if there is a violation of consumer crediting rules, or if there is a violation in sort of any kind of unfair commercial practices, eventually this could lead, of course, it depends upon the judge, but to the civil law sanction and to the, I would say, unfairness and then the nullity of the contract if the essentialia negotiae are affected. Yes, I mean, if I go into the right direction with my comment, and there was this, there were so many cases by the Court of Justice dealing with unfair terms in credit agreements where they were saying that the information is of fundamental importance for consumers, and that the lack of information should result, yes, in, so like Matei or many different other cases. Thank you so much. Thank you.
Would you like Charlotte to start? Address first, comment first?
Maybe Leonike, because I already took the floor, right?
Yeah, I thought, yeah, I took more time during the presentation, so that's why. Well, yeah, of course, I think like Charlotte was suggesting, I think there need more cooperation between our Consumer Market Authority and, yeah, well, civil courts is needed, because the civil courts are in fact representing the consumer in those cases. So we would like that we will plea for more cooperation between the civil courts and or administrative authority. And I was always thinking during writing my PhD thesis that in enforcement you actually need a triangle. It would be very nice when competitors also play a role in sanctioning those information duties, because yeah, that will lead for a better balance, I think, and this takes a lot of efforts of our civil courts. And then, yeah, you come to the question: well, does it fits in the role? Does it fits in the role of the judge to be so, yeah, part of the party actually? So yeah, I think we will plea for, yeah, I think more balance. Am I correct, Charlotte?
Yes, indeed. I think this is key. At this point, some of the civil courts are really starting to behave more as a public authority than as the guardian of the balance of interest between parties, and they tend to forget that civil law is also about balancing, restoring a balance, and this is actually going further than that. So this is, of course, in line with I think what the Court of Justice would like courts to do with unfair contract terms, for example. But in the field of consumer information, we are not sure yet. This is also the way to go. So we were wondering, and that's the reason why now, actually next week, we are going to discuss the possibility to refer a preliminary ruling to the Court of Justice with a civil, with a law court here in the Netherlands, just to be sure. What should be the approach to information duties? Should it be very similar to the approach to unfair terms? Fine, good, okay, but then we need to reassess the whole balance, indeed, like Leonike told us, yeah.
let's go back to our first speaker.
Thank you, Emilia. Well, I know in my case we can refer to CRD or UCPD and so on, but we have two problems. So the Italian Consumer Code provides expressly provides for hypothesis of a protective void when the intermediary violates pre-contractual information obligations, I'm reading, in such a way as to significantly alter the representation of the characteristics of the service. So the final contract could be voidable, but in this area, the Supreme Court tends to reject the idea that the violation of information duties could affect the validity of the contract. Second, I believe for looking to the Italian legal system, of course, according to the authority, the misbehavior was of minimal importance as can be deduced from the using of the ADR procedure. This is a procedure related to minimal seriousness. So I believe that in our system, in fact, we can use the civil sanction looking to actual system. By the way, I believe another useful tool could be the average out consumer. We have to reflect on this notion. I just read the paper of Mateusz Grochowski and Fabrizio Esposito on the evolution of the average consumer, looking to the vulnerability of the consumer in order to enhance the consumer protection. I believe this could be useful, but maybe there is the need for in-depth reflection starting from the scholar and arriving to the courts.
Thank you. Paula, I saw that you had a raised hand previously. Would you like to come in?
Oh, thank you very much. But actually, the speakers have already addressed the point. I had only a comment, and I don't want to reduce time for teacher. Thank you very much. It was wonderful to hear.
Thank you. Vanessa, did you want to come back to continue your discussion?
Well, I think Charlotte has answered my question, but perhaps from the audience, I was wondering if anyone else has comparative experiences from other member states. So how do they deal with sanctions for the Consumer Rights Directive?
Could I just also add from my perspective, because I was quiet because I was giving space to the audience, but there is a positive development here, as I think, from what the Dutch courts have done, in a way where we are often left with this empty space as to what sanction should follow a breach of information obligations. And like assigning a very specific sanction that actually also is tied into financial consequences, also in civil law, so not just having the administrative penalties if you don't provide information, but also knowing you will be responsible financially to consumers, could be an additional incentive to actually comply with these information obligations. And I completely understand that, like, you know, it's completely arbitrary if you decided that this will come with 25% price reduction, this will come with 50% reduction. I also wondered why they excluded an option of full nullity, or it seems like they excluded an option of full nullity of a contract if it's just 25 or 50% reduction. What if one consumer gets all their information wrong, so it's more than free? Does it still come with a 50% reduction? That would seem, I think, a little bit unfair actually towards consumers. So yeah, I see a bit of a positive development, but I also understand the concern of potentially undermining the framework of the Anti-Commercial Practices Directive by not testing any longer for the impact that the breach of information obligations has had on transactional decision-making of consumers. That could be linked, though, so we could ask first courts to first check whether there is an Unfair Commercial Practices Directive breach and application before they follow to the sanctions under the CRD. So you could try to think of a link here of a necessary steps being followed. So only after you see that there was a misleading omission, you then also think, okay, this is also a breach of information obligations, and this should come then with a price reduction sanction, which I understand they haven't done by completely skipping the reference to Book 6 provision. So just a few thoughts from me. Alberto, you wanted to add something here as well.
Yes, thank you very much. And thank you for your excellent thoughts at the end of the discussion, because I reconnect to them. Indeed, I just wanted to mention the Italian experience regarding the Volkswagen case. Indeed, the Autorità Garante della Concorrenza del Mercato, the competition authority, was very fast in sanctioning 2016 Volkswagen for misleading advertising, and because of the software installed in the cars. And this was used by the Court of Venice last year as an element, as an assessment in order to acknowledge the violation, the breach of the so-called fundamental rights of consumers to fair practices, which is listed in Article 2 of Consumer Code among fundamental rights. And therefore, according to that, in order to grant compensation for breach of this fundamental right via extra-contractual liability. So somehow at the crossroads between CRD and UCPD, and this was the first thought. The second, very brief, as regards the effectiveness of the sanctions listed in the Unfair Commercial Practice Directive, and perhaps at that stage thinking at introducing proportionate sanctions, sanction proportionate, as for instance in the regulation on coordinated actions for widespread infringements with the union dimension, avoiding over and under sanctioning, and focusing therefore on at the level of unfair commercial practices, as you rightly stated, it may be a prerequisite in order to act at the roots of the unfairness and to avoid unfair behaviors. So also thinking at making sanctions for unfair commercial practice directive more effective, even given the circumstance that we are facing big techs, which are not very much scared by usual sanction we may have provided in our civil codes.
Thank you, Alberto, for bringing up the Italian case and for your additional comments. I think I will leave this, if it's okay, as food for thought for Charlotte and Leonike further, and we can of course continue the discussion maybe also further on throughout the day, but I don't want to take more time away from the next panel. Thus I will pass on the moderator obligations to Christine Nemeth.
So, Alberto, as I understood before, there was supposed to be a break, but there isn't.
No.
Okay, no, that's great. That's great. So let's just continue. So I welcome you very much to this third session of today, now dealing with the larger topic of unfair terms in consumer contracts, obviously a field of law which has kept us all very busy over the last years. And so in this panel, just to not lose a lot of time, which is a little bit late already, I have the pleasure to welcome two speakers. The first one is Paola Iamiceli. I hope I said that right. And she comes and sees us from the University of Trento in Italy. There she is currently a full professor of private law. And besides that, she's also busy in numerous research projects and I found both at the EU as well as the international level, just to mention UNIDROIT, or the Food and Agriculture Organization she's engaged with. So that's very, very impressive, as well as her long list of current research interests, which don't only include like traditional consumer and business law, contract law, but also enforcement of fundamental rights in the EU, and also the governance of global supply chains, online platforms, and so on and so forth. The title of her presentation for today is Effective Consumer Protection in Times of Global Challenges and the Role of Corrective Remedies from Punitive Nullity to Contract Renegotiation. So just from the title, I'm very much looking forward to your presentation, Paula, and therefore I would like to give the floor to you immediately.
Many, many thanks, Christine. And let me start with congratulations for all the for this event today, and for the celebration of the 10 years of the journal. I'm very happy to start. I'm just checking whether I'm presenting because I don't see very correctly. Do you see the presentation?
Yes.
Okay. The only problem is that I do not see that correctly, and I'm not sure that I can forward this. Okay. Do you still see it? But maybe apparently I cannot go forward. Otherwise, I will ask Alberto to step in, because
you can send me the slides and then we'll be glad to move them.
Yeah, I mean, you have my slides. The only point is that I cannot stop now.
You're right. I will upload your slides.
Okay, I can do this. Okay, sorry for that.
One moment.
Yeah. So I think we can start from the first one, also from the following one. So as I said, it has been a real pleasure to be able to take part into this discussion. My presentation is quite connected with the previous presentation, particularly the one by my colleague Charlotte Pavillon and her colleague from the Dutch, about the Dutch experience. Three questions are on the floor in this consideration. First of all, what has been the role of the Court of Justice in the definition of effective, proportional and dissuasive remedies against the use of unfair terms in consumer contracts? And then what is the impact on national control law of the approach taken by the Court of Justice about the invalidity of unfair contract terms, and particularly why this approach has been particularly critical from the point of view of national law, but also of the EU general principle on sanctions remedies, as we have seen those before. And last but not least, what I would like to discuss with you is whether there is another approach possible to the effective protection of consumer in this field, and why this other approach may be particularly relevant in times of economic crisis like the ones we are facing at this moment. So we can go on to the next, and so the first question, please, so we can go on to the next, please. Yes. Yes, I think I do not need much words about this brief introduction. why we need in the field of consumer protection, and in particular in the one of unfair contract terms, we need an effective remedy, but also a proportionate dissuasive remedy. And as it was said before, not only remedies must be effective, but also proportionate and dissuasive. It is true that particularly secondary legislation refer to penalties when they present the so-called triad of the principle in this field, but we have reason to believe that this term penalty may be interpreted widely, so may be applied both to sanction having a punitive functions and to remedies in the civil domain. I refer not only to the paper for a wider discussion on this point, but also to another paper that will be published, written by myself and Fabrizio Cafaggi on this point, and previous studies of our own on this point. So if remedies also in the field of unfair contract terms need to be effective, dissuasive and proportionate, what about the remedy, the main remedy we have under Article 6 of the Unfair Contract Term Directive, so the non-bindness of the unfair term? I will first focus on the effectiveness and dissuasiveness of this remedy, and then we will come back to the proportionality test later on at the end of the presentation. So next, please. So, thank you. And so why is contract term invalidity an effective remedy? It is, and it shall be, for at least three reasons. The first one, invalidity shall, in the view of the Court of Justice, re-establish equality between the parties and the parties' obligation of rights in the contract. As we well know from the very well-established case law of the Court of Justice, indeed, this invalidity is aimed at replacing the former balance within the contract with an effective balance that reestablishes equality between the parties. So what we can agree is that invalidity indeed plays a sort of corrective function in this case, in the light of the principle of effectiveness. And it particularly does so while preserving the contract as a whole. So what the court seems to suggest is that in particular, it is the partial nullity that plays this corrective function. Although we should acknowledge that over time, and we here refer to Perenisova and Dubek in particular, but also to the latest ruling in the EK 2 months ago, I mean, there is quite some allowance of the Court of Justice towards also the total nullity as an effective remedy in this field. As a third point, if we go to the next, again, in the perspective of invalidity as an effective remedy, invalidity should also enable restitution, because it is only when it enables restitution that the protection of the consumer is quite effective. Now, all these 3 points that we have listed seem quite generally consistent, we could say, with existing contract law at national level. They do not raise too many issues in terms of tensions between the EU law and national law. But when it comes to dissuasiveness, I think that the question is more critical. So we can go to the next and discuss about the question whether invalidity of unfair term should also be a dissuasive remedy. And again, yes, the answer is affirmative. Invalidity shall be a dissuasive remedy in the sense that, with the words of the Court of Justice, it shall prevent the use of unfair terms in the future. And in order to be deterrent and dissuasive, restitution must be added to invalidity. So far, so good. Again, I mean, these 2 points are quite consistent with national contract law. They do not raise particular problem until we come to the third point. So we can go to the next. What are the consequences of the deterrent effect of invalidity on the capacity of the national court to fill in the gaps left by the unfair terms once the unfair term is declared not binding anymore? Now, what the Court of Justice has been quite firm on since, we could say, 10 years ago. I mean, Banco Español in 2012, then Asper Bruce in 2013, is that in order to ensure the deterrence effect of contract invalidity, unfair terms may not be replaced nor modified. Now, what is important to underline is the Court doesn't say that Article 6.1 prohibits contract modification and integration. It says that Article 6.1 shall be interpreted so as to impede and prevent the national court from modification and integration of the contract. So the legal basis for the ban against contract integration is really the deterrence effect, the fact that the remedy must be dissuasive. And then once we accept that, the consequence is that actually the contract term invalidity doesn't only play a corrective function, but also a sort of punitive function, because the lack of contract integration does not only deprive the professional of the benefits that he would have gained from the unfair term, it would also deprive the professional of the gains that he would have gained from the application of any other suppletive norm provided by national legislation. The case of penalty clauses is quite clear, because if we have an unfair penalty clause, what happens, and there has been quite an interesting ruling from the Court of Justice Kanyaba a few years ago, is that not only the penalty clause is not applicable, of course, but also that the professional cannot rely on suppletive norms concerning contractual damages for breach of contract. This is really a punitive effect. So, and then we come to the second point. Please, next. The second question. So what is the impact on national control law, and why this impact is particularly critical, also from the viewpoint of general principles on sanctions and remedies? And then we go next. And indeed, two considerations arise. The first one, from the perspective of national courts. National court, because of this case law of the Court of Justice, must disapply national provision enabling for judicial adjustment of unfair clauses, for example, in the case of penalty clauses. But even more, they must disapply suppletive norms as gap fillers in the contract. And this is quite strong. And this is why, this explains also why we have so many preliminary reference to the Court of Justice, because of these national courts facing the tension between internal and national legislation and the European ban against contract integration. But then also other questions arise. We have signed that the nullity in this case is kind of punitive remedy. But is it always a proportionate remedy? In this case, isn't there a risk of over deterrence in some cases at least? But even more, last but not least, why is contract integration just as such, in both cases by means of judicial interpretation or application of national suppletive provision, is intrinsically unable to restore the effective balance? So why is it not possible to restore the effective balance between the rights and obligation of the parties through contract integration? What the court seems to suggest is that automatically when the contract is integrated, it is done in favor of the supplier. It is not a rebalancing exercise, but it is a reduction of the deterrence effect. And this is why we come to the next slide and then we come to the third question before coming to the conclusion. So is another approach possible in the view of the Court of Justice? Indeed, this approach is possible. We can go next, please. Indeed, the Court of Justice, and this is the evolution since Kansler, so in 2005, 13, another approach is possible, enabling the contract integration, the integration of the contract once the unfair term is declared non-binding. So indeed, the national court may integrate the contract, replacing the unfair term with a suppletive provision, so as to avoid the annulment of the whole contract when this annulment is caused by the non-bindingness of the unfair term, that is a court term. Indeed, if we have an unfair term that is a court term, let's imagine a term that defines, for example, the price of a loan agreement, so the interest, the ordinary interest paid in the loan agreement, then if we declare the court term non-binding, the risk is that the whole contract would collapse as a consequence. So in order to avoid the collapsing, so the annulment of the whole contract, since the annulment of the whole contract would cause particularly unfavorable consequences, in these particular circumstances, the Court of Justice would admit contract integration in order to avoid the collapse of the whole contract. Just consider from a practical point of view, then if we have, for example, a loan agreement and the loan agreement is annulled as such, so totally, then the consequence is that, for example, the consumer has to repay the whole money that he has borrowed from the bank. So in this case, the contract integration is indeed allowed. But this is not, the most interesting part of this story. We can go next. What is very interesting in this, in this case, is that what happens if contract integration is not possible? Because what the Court of Justice has said is indeed that this kind of rule that permits to save the validity of the whole contract is only applicable if a suppletive norm exists at the national level. What if a specific suppletive provision doesn't exist and we need, for example, to refer to more general clauses? Well, in these cases, yet the annulment of the whole contract would cause particularly unfavorable consequences for the consumer. In this case, these are recent cases that we can refer to. One is Banca B from 2019 and one is Lombard, very recent in March this year. The court has been very firm, saying that in these circumstances, the national court must take all the measures necessary to protect the consumer. So it has opened up the floor also to contract integration somehow, because we should avoid with all resources at national level that the whole contract could collapse, causing those detrimental effect for the consumer. And what are these measures? So we can go next. What are these measures? Two measures have been suggested by the national courts, of course, and approved somehow, considered consistent by the Court of Justice. In Banca B, the measure was inviting the parties to negotiate on the basis of a framework set by the national court that is aimed at establishing an effective balance. Whereas in Lombard case from this year, the measure was a sort of unjust enrichment, so that the consumer is ultimately in the position that he or she would have been if the term had to be unfair and never existed. So, I mean, very recently we have come up through the work of the national courts, referring the question to the Court of Justice with this two new remedies actually in the field of unfair terms that indeed permits to protect the consumer without totally sacrificing, the contract. Of course, many questions remain on the floor. I will not have time to go there. Please go next. But what is very interesting here is the point in which the court says that this power of the court to either invite the parties to renegotiate the contract or to reestablish the rights and obligation of the parties through unjust enrichment shall be limited within the limitation of, let's say, proportionality. So that it may only exercise when it is strictly necessary. It cannot be exercised freely. This is a way to say that the remedy must be proportionate, actually. And then the question is, why couldn't we apply the same principle of proportionality more generally when we have an unfair term that is not binding and we need to somehow replace and readjust the balance? Why can't we use proportionality to guide somehow the judge in this readjustment? So, and this we can go next. I think that I've really, exhausted my time. I will only come to very next conclusion. Maybe we can go to the last slide directly. Of course, here the question is whether this wider openness towards contract integration and this attempt to overcome the total ban of the Court of Justice against contract integration may be also consistent with the times of crisis that we are facing at this moment. Indeed, I think that this is very in line with what has been discussed this morning also in the framework of sustainability. Saving the contract rather than abolishing the whole contract is very consistent with a rebalancing function that takes not only the consumer interest into account, but also the consequences for all the suppliers facing the effects of unbindment, of non-bindingness of unfair terms. Through the use of proportionality, probably we can use contract integration so that more contracts, let's say, can be saved, also when they are affected by unfair terms concerning court terms. This, of course, brings, and this is very much linked with what was discussed by Charlotte Pavillon at the end of her presentation. This, of course, risks to create quite a workload for judges, probably impacts on the length and the complexity of the proceedings. And this is why we do need a complementary measure, including more clear guidance on the remedial framework, on the choices of remedies, on the functioning of remedies, not only through legislation in terms of hard law, but also through soft law. And I very much appreciated the contribution and the conclusion of the previous presentation in this regard, although I should observe that it's not very much in line with what the Court of Justice has recently suggested in Lombard. Yes, I think that this would be the start of another presentation, so I stop here and also apologize for taking a few more minutes of my presentation. Thanks very much.
Thank you so much, Paola, for this both very informative as well as innovative perspectives you have presented. As we are rather advanced in time, I will proceed directly to our next speaker, who also comes from Italy. Riccardo Serafin is a PhD candidate in law at the University of Torino. He has recently also been awarded, not just Italy, a Magister Juris from Oxford University this year. His research interests include mainly comparative law, international commercial law, and also international private law. This is very much reflected in his doctoral thesis he's currently doing at the University of Torino. And the thesis deals with non-compensatory remedies for breach of contract, comparatively in English and Italian law. His presentation today is titled "The Court of Justice on Unfair Terms and Supplementation of the Contract. How far is too far?" So therefore, not losing much more time, Riccardo, the floor is yours. I'm very much looking forward to your presentation.
Thank you very much. Thank you very much for your kind introduction, and thank you, Professor De Franceschi, and all the editors of this journal for the invitation. It's really a privilege to speak here today. And as a matter of fact, my presentation is extremely in line with the previous one. I will also talk specifically about the management of those gaps in the contract resulting from the elimination of an unfair term. So why should you listen to my presentation, since we already had fantastic presentation before. Well, I will try to give a more perhaps radical, less nuanced approach. So hopefully you will hear a slightly different perspective. And secondly, what I wish to do at the very end of my presentation is try to use this saga, this experience, as a sort of case study to see if we can perhaps gain some valuable lessons about the role and the limits of the Court of Justice case law in the development of European consumer and market law for the future. So without further ado, let's start by very briefly summarize the historical evolution of the topic. Professor Iannicelli actually already touched upon all the points. I would just give you a very brief, I would just put things into a line, a temporal line, just to give you a more understanding of the topic, a more understanding of how this thing evolved. So we had Article 6 of the Directive 13 of 1993 that merely stated that if in a consumer contract the term is found to be unfair, the said term shall be not binding on the consumer. A very technical, opaque provision doesn't tell us really anything on the consequences for the content of the contract. And so it's not surprising that litigation rapidly emerged in this area. The first case was actually a case called Banco Español de Crédito, delivered in 2012. And on the facts of the case, the Spanish judge wanted to reduce an unfair interest rate clause for delayed payments as allowed under Spanish law. The Court of Justice, however, ruled that the national judge was unable to revise the content of the term found to be unfair. Problem is, there remains some debate on the exact scope of the rule, but these doubts were rapidly gone by the time we reached our first landmark case on the topic in 2014, the Kassler case. And in Kassler, the court unequivocally curtailed all attempts to supplement a gap left by the removal of an unfair term, not only by judicially revising the contract, but importantly, also by resorting to national statutory default rules. Or now, the main idea, the mere obliteration of pure nullity or whatever we want to call it, is that the contract must be left as it stands after the complete obliteration of the unfair term. Nothing more, nothing less. But here comes a problem, as Professor Iannicelli already said, the Kassler exception. So if we have a core term and the contract cannot continue existing without the said term, then it's possible to resort to supplementary rules if the consumer would have unfavorable consequences. Now this case was later refined and clarified by our second landmark case in the area, which was the case in Zubiak, rendered in 2019 and still confirmed very recently in September this year. And we have two very important qualifications that should be made here. Firstly, it was held that when assessing the consequences of the avoidance of the entire contract in terms of are the consequences particularly unfavorable for the consumer, the express will of the consumer is decisive, is final. So in other words, this means for me that the consumer can individually choose at this point whether to consent to supplementing the contract at that point or leave it ineffective once and for all. The second qualification is that decision deals with what sources can be used to fill this gap, because I talk about statutory default rules, but we also have non-statutory rules. So in Kassler, there was a statutory default rule, so there was no problem about that. But in Zubiak, the Polish judge tried to avail itself of a provision of the Polish Civil Code, saying that the effects of a contract may be supplemented not only by a statute, there was no statute at the point, but by principles of equity or established customs too. The European Court, however, refused such an approach, ruling that the directive must be interpreted as precluding gaps in the contract from being filled by resorting to these non-statutory sources. So expressly equity or usages, but most likely that also includes good faith, reasonableness, and alike. They are very present in European civil codes. Now, although the reasoning is very short and unclear, I think personally, the court's decision was based on the assumption that these later sources, so non-statutory default rules, were non-subject to specific assessment by a legislator. And that meant that the legislator could not establish a reasonable balance between the rights and obligation of the parties. And consequently, the court held they cannot be presumed to be fair. Therefore, just to conclude this very short summary, I think we can restate the law under 3 pillars at this point, the current law. First, the abusive clause must be obliterated entirely. The judge can neither correct nor replace it. Second, the clause, however, may be replaced if the contract cannot continue in existence without it and the consumer affected does not oppose. Third, in any event, an abusive clause can only be replaced with a statutory default rules. Judicial supplementation is never permitted. So that's the descriptive part. As for the normative evaluation of the law, I will not spend too much time on very specific criticisms, but I will try to just give you a succinct argument about why I think this area is messy and problematic. So starting from the mere obliteration doctrine, so the first pillar that I said before, the path taken by the court, in my opinion, mixes up 2 different techniques. Because I think we must distinguish between judicial correction of the unfair term and legal substitution with another supplementary rule. In the first case, the judge revises the content of the unfair term to the extent that it eliminates the unfairness. Such a method is inadmissible, and this was correctly found in Banco Español de Crédito. Manipulating the content of the clause means recognizing that the terms continues to exist, albeit to a limited extent, but it still continues to exist. And this could guarantee the trader the partial preservation of the advantages deriving from the use of the clause, since the elimination of the unfair component could still result in a better situation for him compared to the supplementary law applicable absent any agreement. However, when a term is removed in its entirety and the resulting gap is supplemented according to the generally applicable default rules, I think we have an entirely different scenario here. In this case, the consumer is placed in the same position as if the term had not been included. And this is the natural consequence of non-bindingness. If the clause is regarded as never having been included, there is no reason not to regard the gap thus created as any other gap in the contract. So my idea is that the supplementary law in no way preserves the unfair term, but just guarantees the restoration of contractual normality by means of a rule aimed at rebalancing the relationship between the parties. So if we care about correctiveness, that's the correct rule. But in reality, the court also, or more than anything, cares about punishing the trader and ensuring deterrence, as we already said, and the court explicitly acknowledges that. But I think this is open to some criticisms. First, this creates a major political problem in terms of political legitimacy in doing that. The decision taken by the court, I think it's first and foremost a policy choice at this point about the desirable role played by the Unfair Terms Directive. The court is trying to achieve systematic results in the market by using contractual relationships. And this is a goal-oriented, functionalist approach, however you want to call them. It has been exercised many times and has undoubtedly led to a significant development in European private law. But in doing so, the court risks to overstep its proper task, both with respect to other European organisms and with respect to EU member states. Indeed, the treaties delegate the legislative power to European Parliament and Council, and the principle of subsidiarity and proportionality, enshrined in Article 5 of the Treaty of the European Union, preserve a prominent role for national legal systems. Against this backdrop, I think the ambitious rulings of the court must be taken with great caution. This is not to say that the court should just do a minimalist or literalist interpretation, but what I'm trying to argue is that we must draw a line between admissible and inadmissible interpretations. And in this case, if we really want to impose punitive features or overly dissuasive features in the management of unfair terms, I think that in light of the importance of the decision, and given that this direction goes against the traditional understanding of contract law in the legal traditions of member states, this choice should be left to the political process, should be more clear. However, And moreover, the new Article 8b of the directive, recently included, binds states to adopt sanctions against traders who use unfair terms. These sanctions must be effective, proportionate, dissuasive, and take into account the nature and gravity of the offense. Now, I think that these new sanctions already address the punitive and dissuasive functions at this point. And if this is so, I think that nothing really prevents us from rereading Article 6 in its more natural function of ensuring a fair balance of the contract. So that's my first point. Secondly, I question whether conditioning the supplementation of the contract to the will of the consumer is appropriate. In the sense, undoubtedly, the consumer has a choice between accepting the unfair term as it stands or eliminating it. But once the term is eliminated, the consumer should fully accept the legal consequences arising therefrom according to the applicable law, without being able to additionally request the annulment of the contract. Doing otherwise, I think, infringes on the principles of favor contractus, according to which a contract should be preserved whenever possible. And such a principle is explicitly embodied in Article 6 of the directive, as I already said. Well, I didn't say that, but I mean, Article 6 just said that the contract, free of any unfair terms, continue to exist whenever it is so possible. So quite clear in that in this regard. And so my understanding is that except when the law governing the contract is unable to supplement the contract itself, and the contract cannot exist without the unfair clause, the natural conclusion must be that the contract continues to bind the parties. The consumer should not have a choice of freeing himself unilaterally. And in fact, I think this power is prone to abuses, especially in the sense that the consumer may escape a bad bargain at a certain point. That generally the law doesn't want the consumer, doesn't want a contracting party to escape a bad bargain. So this is something that deserves a little bit more, I think, attention from scholars and especially from the court. Thirdly, and finally, it becomes really, really hard to justify the court's skepticism towards non-statutory supplementary rules. It certainly cannot be explained in terms of consumer protection. We'll talk a lot about consumer protection today, but this ruling actually lowers consumer protections. In fact, the impossibility of saving the contract and absence of a statutory default rule harms the consumer if this would expose him to negative consequences. And this was explicitly acknowledged by the Advocate General in our conclusions in Banca Transilvania of 2020. And of course, as Professor Iannuccelli suggested, we may see in recent cases some attempts to use the law of unjust enrichment or further negotiations in good faith as a way to circumvent this problem. But that's rather problematic because we don't know if these instruments are effective, and in any event, they are too much complicated. Why doing that if we can just abolish the Zubiak rule if it doesn't make any sense? Why using indirect means when we can use a more direct mean? Alternatively, some people have tried to argue, though, that Zubiak can be justified because the court was moved by the concern that judicial supplementation could lead to divergent solutions for consumers in various EU member states. But I don't think that's right, because the court admits supplementation by national statutory rules that to a very large extent are not harmonized, let alone unified. So the real reason why judicial supplementation is rejected lies in the court's apparent dislike for an active and creative role of the judge in determination of the content of the agreement. It seems to be the classic fear of judges rewriting the agreements for the parties. But in my view, the court fears that judicial supplementation, basically, it appears to be a technique excessively unpredictable and potentially arbitrary. And this, I think, explains why the court puts so much emphasis on the legislative process. Because if rules are written and general, as the rules in statutes, then we can know that and assess. We can know them in advance and assess them. So we have a more clear and predictable legal framework. This may make sense, but I think this is another policy choice. And that comes with all the risks that I already discussed before. Furthermore, I think another criticism is the court is too much influenced by a civilian mentality here. So in civil law systems, due to their historical evolution, we're used to generally have a large group of statutory supplementary rules for various types of contracts. So it kind of works in civil law system, but in common law countries, and despite Brexit, there are still common law countries, most notably Ireland in the European Union, only a few rules are contained statutes, and supplementation is left to courts by the implication of a term, either in fact or by law. So I think the current case law penalizes unduly common law jurisdiction and their peculiar legal experience. And in general, it penalizes all those countries that do not want to have, very specific rules, written rules, but prefer to have more general provisions to deal with to a larger extent with cases with different, leaving the choice to judges to develop rules when a proper case comes up. And on top of that, I think that since the current directive only seeks minimum harmonization, it's improper to think that it dictates a specific method for how to deal with the consequences of unfair terms. And so nothing really militates, I think, against the use of alternative sources, especially if the result is in favor of the consumer party, because then we have this rule in Zübig, the lowest consumer protection, whereas the other rules, other pillars I discussed before, just increases consumer protection no matter what. So I think that's rather problematic in terms of coherence. So my fairly radical thesis is that the directive, in sum, does not prevent the supplementation of gaps resulting from the invalidation of unfair terms, not only when they pertain to an essential clause, but also when ancillary clauses are at issue. I also think that the only limitation that the directive imposes is that the judge cannot revise the content of an unfair term in order to partially save its effects. I also think that there is no reason why supplementation should only be carried out by statutory default rules. Also, judicial implementation according to the applicable national law should be permissible. And in any event, supplementation should not be conditional on the consumer's will. Now, I recognize that this is very radical. This is asking a lot. The court is very reluctant to overrule its previous decision. And I also acknowledge my proposal would produce what some might call a step back in the European harmonization process. We talked a lot about civil sanctions. It seems not to be the direction we're taking. But I think that if the problem is that the foundations of the law are quite problematic, the law in this area is very messy, and we have lots of precedents that are very difficult to reconcile here, as perhaps I mentioned before. And this is problematic because if we keep developing the law in the future based on the wrong foundation, we may end up in a difficult situation or with a law that just takes a wrong turn. And I believe this is the main lesson here. So in the sense, I believe that this area of the law is entirely judge-made. And I think that demonstrates that there are some limitations on the Court of Justice's ability to promote legal convergence while remaining coherent, principled, and within its institutional roles. So I talked about political legitimacy. I talked about the scarce attention paid to the normative rationale of some exceptions, especially in Zübig. The court never really address fully or convincingly why this exception in Zübig exists for non-supplementary rules. And I also think that in general, this saga shows that the court is not really engaging with national legal systems or the interplay between consumer and contract law. But this is a crucial issue, and some of the presentation highlighted that. And I also think that some of the cases in this area are quite poorly reasoned. Usually the court just makes some references to past decisions, but doesn't really engage with the core materials. And I think the main reason, a reason that is a bit underexplored, in my opinion, is how preliminary ruling proceedings work. So, contrary to common law courts, the Court of Justice of the European Union cannot engage with specific facts of the case. It's not a fact-sensitive approach because facts and the conclusion of the case is left to the national judge. And the court actually has to come up immediately with a general solution applicable for all EU legal actors. And that, in my opinion, results sometimes in very broad and abstract rules that are quite puzzling. So, for example, in Canieba, there's this idea that you can't resort to the to the default rules for damages, for claiming damages in case of breach. And it's quite puzzling. The court doesn't really develop on that or the potential implication on the case, because it can't, because that's how the court just works. But I think this hinders an incremental and structural development of the law. And this is a problem if we want to rely on judicial development of the law for the future. So I think we have to be really careful here, not just in the field of unfair terms, but in the whole field of European private law. And just very, very conclude, I'm not suggesting that the court has no role to play for the future. The court is an important actor, has done a lot for European integration, for the development of EU private law. And that's very important. The court has certainly a role for the future, but we must be very critical, I guess. Must be very critical of the past, because sometimes the court may have made questionable decisions, not necessarily wrong, but questionable. And sometimes we may want to just stop and face back for a while, asking ourselves whether we've gone too far without perhaps even realizing it. Thank you. That was basically my presentation.
Well, thank you very much, Riccardo, also with this enlightenment. And I do think I saw some faces. I'm very, very sure there are some contributions, remarks to the discussion. So I would like to give the floor to comments, speaking up in the chat, raising your hand, whatever you prefer. You're very welcome. I saw Charlotte's eyes talking. See?
May I, Christine?
Of course.
This is a topic I've been investigating for 3 or 4 years now, and this is really interesting to see that this is actually really beginning to gain momentum also in other member states, because this is really a very relevant topic in the Netherlands for 3 or 4 years. It looks like we are always like taking the initiative when it comes to sanctions. And for example, the Dexia case, which also has confirmed that falling back on supplementary law is not allowed. A recent Austrian case has also actually confirmed this. Mm-hmm. This topic is actually also a very complicated one, because on the one hand, and this is actually when I mentioned earlier that remedies have two sides. They can be remedies are there to actually repair and to redress the balance for consumers. And on the other hand, the court actually, because this is court jurisprudence. This does not follow from the directive itself. So this is the court actually asking from civil courts to apply deterrent sanctions, and this sanction is actually the very remedy from Article 6 that is available to consumers. So we have this impossible mixture of at one time having to recalibrate the contract to redress to redress the equilibrium, and on the other hand we have to make sure that a trader who uses unfair terms is not actually is dissuaded from using them again. This is not getting any advantage, and this is actually very that is nearly impossible, because on the one hand, if you just keep the contractual balance, this will always be the safety net a trader can fall back on. And on the other hand, it does mean that this trader does not experience any harm or any detrimental consequences from using the term. So you have to go a little bit further and maybe let the consumer gain an advantage. And that is what is happening, for example, with penalty clauses. Those consumers are actually able to default their contractual obligations without experiencing any consequences. And that's the choice actually the court has made as of now. But it's from a private law perspective, it's really difficult. Mm-hmm. And this is something even Dutch courts, which are very much prepared to give a 50% price reduction for a lack of information, are struggling with. Because the Dexia case is actually a question by a lower court in the Netherlands after the Supreme Court indicated that supplementary law is a matter of national law, national contract law. The directive does not regulate national contract law, so why would a national provision of supplementary law not be applicable? So I'm really wondering how, because this is really a fundamental question about how contract law and the directive relate to each other, and how punitive, how deterrent remedies should be when applied in an ex officio setting. And of course, this also relates to the role of the judge, and there you see also this difference between maybe Eastern Europe, Western Europe, the South, the North, etc. Because from what I understood, I'm not a specialist of German law, but I understood that the highest German court has actually refused to apply the Jubac approach. We are going to complement the contract as a court because we are used to do so, and that's actually what I'm also advocating in the Netherlands, because our courts feel really at ease with those open north general clauses. Why would they be prevented from applying them in this specific context, whereas they can apply it in all other types of contractual disputes? So sorry for my long remark, but I'm really curious about how you're looking at this impossible trade-off.
So thank you, Charlotte. I think we're like every member state is currently struggling also with like sort of overstepping, and also like for me it always had a sense of like it's a competence problem. You have all these, even the ex officio thing, it's something, it's like the European Court interfering with actually even worse, not only contract law but also procedural law. So this is, so whenever I hear something like let's just not do it, I very much sympathize for this. But I shouldn't talk on the tear. So please, speakers, this was directly addressed. Would you like to respond briefly? Because I think we're already 1 minute over the time, but then it's lunch break. So I thought maybe it's okay. Alberto, you tell me it's your birthday, so you can make a wish. How much from the lunch break we can actually cut off. But maybe the 5 minutes is definitely okay. That's what I should think.
Please take the time you
take the time you need. Okay, that's great. So I can give the floor back to the speakers. Thank you very much.
Thank you very much. I don't know whether, I mean, of course, Ricardo, feel free to intervene before me. There is no priority to be respected. Otherwise, I will say a few words. 1 minute.
Just go on.
Sure. Okay. Well, let me maybe connect to. I mean, I totally agree with the Charlotte's comments. It's totally true point. I think that one way to see at the point is also, I mean, to decide whether we really want to attach to this civil law remedies punitive functions. So whether this dissuasiveness, this deterrence dimension that is so important for the Court of Justice transforms actually the civil remedies in a way that they are punitive functions. I mean, change totally the way in which national courts should apply those. If that is the case, then I think that we have at least two challenges. The first one is that if the remedy is a punitive one, then I mean we cannot escape proportionality. I mean even more. I mean proportionality applies anyway, but even more if the remedy is a punitive one. Then you cannot apply just the same rules in all the cases. So this is why I like, although I do understand the complexity, but I do like the Dutch attempt, for example, to distinguish different types of ex officio powers or different types of remedies depending on the severity of the wrong that has been made. So at least there is an attempt. Might be, I mean, something to be discussed. It might be not precise, might be arbitrary, to be improved. At least there is an attempt to apply proportionality. The other point that I wanted to make is the relation between civil, private enforcement and public enforcement, because I think that is there. I mean, we are discussing about all these civil law cases because, preliminary references are brought by judges, of course, and not by administrative authorities who cannot refer to the Court of Justice, of course. But then there is an elephant in the room, which is, the public enforcement at the same time. So if priority is an issue, then we have to make sure that we do not impose disproportionate sanctions against business, because we may apply at the same time civil sanctions and public sanctions. So a kind of a coordination between the two at some point should be envisaged at this time. I think this is also something, and even more with the modernization directive, because of course, administrative authorities may impose sanctions in case of the use or repetitive use, recurrent use of unfair terms. So in that case, I think that there is a proportionality issue behind. Thanks.
Thank you. Ricardo?
I would just add very briefly that I think you used the perfect word to describe this problem, trade-off. This is a trade-off, because we may want to go to reimagine the law of contract and other areas of private law to give a deterrence function or punitive function. And that may be a good thing, because I'm not acquainted with the empirical literature that must be in this area, but it might well be that doing that actually has a very positive effect on the market. So that's certainly something it's desirable. But I think it's a trade-off, because if we do that, I think it's almost unavoidable that we end up in a situation where the national private law loses coherence, and we end up with cases that are very questionable. So the idea, for example, that if there is an unfair penalty clause, then we can't claim damages, the trader can't claim damages, it's very questionable, because then the consumer basically means that it can breach the contract and cause harm, but then there is nothing that actually allows the trader to claim damages. And that's very odd in light of our general principles of how the law works. That's very odd also for the market, perhaps. So we can't have the cake and eat it. I think we must make choices here. What's the proper place of public law or private law? What contracts can do? And about that, it's very interesting, this idea of using contract law in a systematic way to achieve reforms in the market. But there is also the problem that contract is about a bilateral discrete relationship. So obviously it has wider effects, but still that core idea remains. So I think for judges, it's problematic to actually, weigh up these two different conceptions also. Like, it's not very easy to see, if I am adjudicating a contractual dispute, I am making corrective justice between the parties, or the parties are just a means to achieve some greater systematic objective in the market. Because that changes our perspective on how contract law works, on what a contract is, and so on, I think. So I think it's really interesting, and we must be very, very careful with these choices, because everything has good and bad aspects. So it's really a trade-off. It's amazing. Yeah. Thank you very much. Yeah.
Thank you very much. Anything you would like to add from side of Paola or Charlotte, or are we entirely happy? I think
just one last small remark, but I don't think at this point, when we look at the Directive on Representative Actions or the Modernization Directive, the Commission is not at all prepared to have this punitive approach to civil law remedies or sanctions. They are just doing like this doesn't exist. I called it a blind spot in the past, and it's still the case. So this is something that is very difficult to sustain in view of the jurisprudence of the court. So something will need to change at the legislative level as well.
Now, the last thing we didn't hear anymore, so I'm not quite sure.
Oh, sorry. I think something will have to change also at the legislative level. Because at this point, it's being ignored from.
All right. So I don't see anybody else having the wish maybe everybody's hungry to contribute any longer. So it's me that is really happy to thank you once more for these wonderful contributions, presentations in my panel. So, and also for your remarks and discussion. And nothing left to say, but that I wish you a very nice and pleasant lunch break and hope to see you back in the afternoon.
Many thanks indeed.
Thanks a lot. Thank you very much.